Adjournment request, if any, from item number 1 to 6.
Yeah, please, your lordship, I beg to mention item number 4. Lordship, 4.
Yeah.
Lordship, this matter will be fixed after vacation, lordship.
Adjourn. Yes. Adjourn.
Yes, lordship. Highly obliged.
May I please, your lordship, I beg to mention item number 6. It may be listed after vacation.
Adjourn.
Bless.
From item number 7 to 11.
Look, my prayer is with regard to item number 10 and 11.
Yeah.
These two matters lordships heard along with Honorable Justice Sham. Perhaps this has to come up before that bench, my lord. If possible, my lord, before vacation, if there is available bench is there. Because there is some urgency in that.
Chinmay is available. We fix that date.
Lordship,
We'll let you know.
yes, yes, much obliged.
For order supplementary list, item 12.
But the lordship has called the officer. Lordship has called the officer, the executive engineer. He has come.
Yes, what's the problem with the construction of the road? You have given the undertaking here that will complete the road by May 2024, and now you are making excuse that the people are obstructing to it. Who are those people?
Some a group of women came, sir.
Why don't you give their names? Why don't you give their names?
In any case, if lordship permits me, by taking police help, we have discussed.
So
By
who
taking police
prevented
help,
them? Who prevented him?
the photographs are here, my lord.
Who prevented him from taking police help?
Nobody.
Then
Now, by police help, they will be in a position to complete the entire thing within
so
20 days.
who prohibited him to take the police help?
In fact, I have seen from
Now today you became wise that he'll take the police help. Why? Why this earlier this was not done when the court's order is there? And as per your claim that their objection is nothing, then why you have not taken the police help earlier?
I find, but he has written to the registry of the honorable court, that and the registry has intimated that a meeting will be held with the local resident.
What do you mean by we are not in that business?
I'll not take your lordship to that. Lordship may kindly give us. They will finish the work within 20 days. Kindly give us 20 days time,
What do you mean by 20 days? Kitna stretch raha hai?
I have given the photograph, that
We are not aware. Kitna stretch this stretch is how long?
25. This I have yesterday given.
How long the stretch is?
25 meter is there.
Only 25 meters.
25 meter.
Do it within a week.
The
Do it within a week, otherwise you will face the contempt. I'm telling you.
gravel
No,
work
we
they
are
will do
not. We are very serious about that.
at three layer.
Once you have given the undertaking, or otherwise will issue a notice that once you have given the undertaking, that the work would be complete by May 2024. Now this almost 20 days has passed.
Correct.
What happened to that?
At three
No,
layer.
we are not granting you.
At three
Either
layer,
do
it
it
will be
within
done.
a week or face the contempt.
Gravel work, kindly for a moment. Gravel work, they will finish it within.
Whatever
then
it may be, complete the road within 7 days. Whatever resources you have, put those resources. Within 7 days, you have to complete it.
So the three layer has to be given.
Whatever it may be. Do
But
it.
the concrete has to be.
If there is a VIP visit, you people are preparing the roads within 2 days.
The
No, we are not concerned.
Really at let's leftover stretch the
Whatever it may be, why you have not completed by May 2024, you're seeking you're taking excuses that the people gathered there, they objected to it. And now you became wise that will take the police help. Why you have not taken this police help earlier?
kindly see the condition of the
Keep
road.
it with you, keep it with you. Do it within 7 days. Or face the contempt. That's all. Do it within 7 days. And after 7 days, come with the report and the photograph that the work is complete. That's all. Okay, pursuant to the direction given by this court on 19/6/2024. The executive engineer PWD New Guwahati Territorial Road Division, Guwahati, is personally present before this court. Full stop. It is noticed that on 2/4/2024, learned senior advocate, senior government advocate Assam, Mr. Dinath, has assured this court that the construction of the alternate road shall be completed by the end of May 2024. Thereafter, on 27/5/2024, again, Mr. Dinath has gave assurance to the court that the construction of the alternate road would be completed by the mid-June 2024. Full stop. On 19/6/2024, the statement was made by Mr. Dinath that the construction of the alternate road could not be completed on account of some trouble created by the local residents. Full stop. The same statement was also made on 25/2024. And on that day, we have directed Mr. Nath to file an affidavit of the concerned official with the detail of the persons who have created trouble, who are creating trouble in construction of the alternative road. Full stop. No affidavit was filed pursuant to the direction given by this court, and therefore this court was forced to direct the executive engineer PWD New Guwahati, Territorial Road Division Guwahati, to remain present before this court today. Full stop. Mr. Dinath has now submitted that the department has decided to take the police help for completion of the construction of the alternative road. Full stop. It is strange that a said decision of taking police help has not been taken earlier when the local residents have created trouble. Full stop. Be that as it may, we direct the executive engineer PWD New Guwahati Territorial Road Division Guwahati to complete the construction of the alternative road by June 2024. This matter on 27th of June 2024. On that day, a completion report along with the photographs we produce before this court.
But technically, they said at least 10 days time is required.
Yeah, whatever the technicality, we'll see to it. On 27th of June,
The report they will definitely give.
if there is any VIP visit, then you are going to construct the road within 2 days.
But this,
Without all technical specifications will taken care of. Nothing doing.
Here the situation is little bit.
Okay, let us see.
Lordship.
Don't do it.
No, no.
We'll
No, no,
face
they-
the consequences.
They
Don't do
will,
it.
they will do.
Yes.
Only the technical aspect.
Okay, don't do it. If you are unable to do it, don't do it. We'll see to it.
No, no, to the extent possible, they will do.
Yes. Next.
Deep daily list for admission item 1.
The petitioner before your lordship has admittedly taken a loan from the Punjab National Bank. Against said loan, my lord, there is an outstanding amount of around,
What happened on 14/6/2024?
my lord, out of the 3 properties which they have put to auction, they could get bidder for the residential one, and for the other 2, they could not get bidder. My lord, my submission is this, my lord.
Deposit that amount and get your residential whatever the portion free, get it free. Deposit it.
Now, my lord, since I do not have that financial capacity as on date, my lord,
Then why you have made this statement before this court?
my lord, we said that let them go ahead with the property number 1 and property number 3.
And if there is no buyer for that property, how they'll go ahead with that?
Now, my lord, I had instruction from my client yesterday, my lord. They said because the base price has been high, my lord. Because the total loan amount, my lord, will kindly see, my lord. In fact, my lord, while we avail the loan, the properties that we have mortgaged were,
Okay, you show us authority of the court while exercising power under Article 226 to issue such direction. Will issue a direction. You show me any law, please show us any law. The law is otherwise.
my lord,
In securitization matters, no interference.
my lord, here, my lord, we are not challenging the auction sale as
You
such.
can't even, and you can very well challenge it, but not before this forum.
Before the deal, we are only seeking some accommodation, my lord, since it is a residential.
Already the accommodation was granted by this court on 14/6/2024. That's all.
My lord, I am aware and alive to the situation that since we have taken the money, we'll have to repay it. My lord, we are not.
Why these people attempts on your part?
No, my lord, because my lord,
Either pay it or get the property
No.
auction.
no, my lord, the only thing is that, my lord, the property number 1 and 3 covers more than what I have.
Okay, then show us any law that we can issue a direction to them that first sold this property and then sold this property. Show us any law. We'll do it. Ultimately, it's a court of law.
My lord,
We have to pass an order in accordance with law. Show us
My
any
lord,
law, we'll pass the order.
my lord, on the side of it, because my lord, moreover, my lord, this property residential plot was in fact a collateral security. My lord, in fact, this residential plot was the collateral security. The primary security was the industrial, that factory, and this is the primary
Okay,
security.
then show us any law on this point also. Okay, first of all, the bank is obliged to put to auction those primary
Primary.
mortgage property and not the collateral. Show us that law.
My lord, my lord, yesterday I tried, I could not lay my hand. My lord, can it be on
You
Monday?
will not find any.
Can it be on Monday, my lord?
You will not find any.
The
No, my lord,
confirmation has
I'm-
been stayed. Confirmation of the sale has been stayed, my lord. So I'm unable.
Yeah, that's right. We have already, this court has already granted indulgence. Otherwise, and that's the problem here. Once the indulgence is granted, then again, the new demands will come.
No, my lord, we are not saying that we need a right over the resident as on date. My lord, if they could
Okay,
leave,
whatever, if you are having some point, go before the DRT, raise your whatever points you have, if you have valid point, the DRT will grant you the relief.
my lord,
Go and approach the
DRT, my lord, because the condition of my client as on date, my lord, because DRT, the court fees and other things are also at a very higher side, my lord.
What do you mean by that, sir?
My lord, it is around some percentage of, I'll have to check, my lord, some percentage of the, this has to be deposited as a.
Sir, you are making, if that is so, that is the law. That is the law.
Now, subject to what your lordship,
Since you can file a petition by paying some hundred of rupees, so you approach the court.
so that,
That can't.
No, my lord, only to the limited extent that, my lord, let them auction the primary.
Okay, sir, we'll issue a direction, show us the law. We'll issue a direction. It's better to approach the DRT and raise all these points.
My lord, my lord, on 25th, can I just,
After, either today or otherwise we are passing it on.
my lord, today at 2, my lord, I'll try. At 2, my lord, I'll try.
At two, this bench is not available.
My lord, the only predicament is that is the residential.
Whatever the predicament is, show us the law and get the relief. If there is no law, this court is not supposed to pass any order, illegal order. That's, we make it clear.
Because, my lord, otherwise also they will have to again auction my.
We'll pass an order on merits also, or you get it withdraw and approach the DRT.
But in that event, can I have an instruction after,
Yeah,
maybe
please.
after 1 or 2 items, my lord?
Okay, fine. Pick up this matter after 5 minutes.
Item 2 and 3.
May I please. Malad, this PIL was malad regarding that Assam road project.
That's right.
Now, last
But-
occasion, they took time, my lord.
But today also my senior is out of station. Lordship.
Malad, last
Next week,
occasion,
any day, Lordship.
malad, as per their affidavit, my lordship, all the beneficiaries belong to the NC Hills Autonomous Council.
In the name of the NCL,
Yes,
many of this compensation was, or the, whatever the amount that was paid to the NC Hill Council. What is the, NC Hill Council is distributing compensation to itself.
my lord, your lordship, I pray, my lord, that the revenue officer may be called for. He is the member secretary holding the fund.
Revenue officer.
Yes, my lord, respondent 9, my lord. Revenue secretary may be personally, my lord, lordship directly.
Ask the respondent number 9 to come, to explain
Yes, my lord.
that how this money is dispersed by the NCL Council to itself.
Lordship
In
can
lieu of
take
the
up the matter
compensation for acquisition
Monday,
of the land. Clarify it.
Lordship
They
can take up the matter
affidavit-
Monday, Lordship.
In their affidavit, they filed this additional affidavit on 21st of May 2024, in which there is a specific assertion with a chart.
Yes. Page 410.
410.
Yes. These are the names, my lord. It starts from page 413.
In fact, here the paging is 4,
It's my affidavit reply.
427. What about this? Some of them. Here. Name of the thing. Name of the thing.
Yeah. 60. Up to 60. Up to 60.
Up to 60. Something that we have distributed expenses one for monthly. When this PIL petition, the petitioner has, the petitioners have raised a grievance that the people belonging to the scheduled tribe in bracket Hills community in the district of Dima South has been evicted from their land in the name of Akshom Mala Road construction without paying any compensation. Stop. The respondent NC Hill Autonomous Council has filed an affidavit on 18th of March 2024 claiming that around 1534 affected persons from whose land has been required has already been paid compensation in lieu of acquisition of their land. A detailed chart indicating the name of the beneficiaries along with names of their villages has also been produced along with this affidavit. Full stop. In counter to the said affidavit, petitioner is the Soron Heger is the petitioner. Hesger is the petition number.
My lord, respondent,
No, this the person who has filed the affidavit
yes,
is
my,
petitioner number 1 or petitioner number 2.
yes, yes.
In counter to the said affidavit, petitioner number 2 has filed an affidavit on 21st of May 2024 mentioning that as a matter of fact, the list submitted by the NC Autonomous Hill, a list of persons submitted by the NC Autonomous Hill along with its affidavit is not correct and has pointed out that in the said list as many as in the said it is in the said from the said list it is indicated that 66 numbers of the beneficiaries to whom the compensation is dispersed is NC Autonomous, NC Hills Autonomous Council itself, who is authorized to distribute, to disperse the compensation to the affected persons. Full stop. It is submitted by the council for the petitioner that the distribution of the compensation to the affected persons by the NC or Hills Autonomous Council is not fair and required to be proved. Stop. And it council appearing for the NC Autonomous Hill is directed to clarify the anomaly pointed by the learned counsel for the petitioner through the counter affidavit of petitioner number 2 dated 21st of May 2024. Is this matter on? When?
Well, let it,
When?
Lordship, by 27th May. Please,
27.
but 20th of May, no.
27th of June.
Mala, this revenue officer, Mala, he is the member secretary and authority to hold the money.
Let him file an affidavit.
Because the issue was direct purchase, Mala. The issue was, Mala, direct purchase of land without any settlement.
Let them.
Yes.
Let them file their affidavit, clarify this situation. We'll consider.
Yes. All right.
Yes, Mr.
Item 1.
Have liberty to approach the DRT.
After attempting the matter for quite some time, then the concept of the petitioner on instructions has submitted that he wants to withdraw this writ petition with liberty to approach the DRT under section 17 of the Securitization Act. Full stop. Dismissed with liberty as played for the interim order passed by this court on 14/6/2024 is automatically came to an end. With the dismissal of the writ petition as withdrawn, the interim order passed by this court on 14/6/2024 shall automatically came to an end.
Let us give the liberty to approach. Mala.
Yeah.
Liberty is granted.
Liberty is there. Liberty we have.
For hearing, item 5.
Yeah, please. Well, in this case, the writ petitioner had approached this honorable court in the writ petition because he was denied his promotions to the rank of assistant sub-inspector in the Central Reserve Police Force from the post of head constable only on the ground that he had suffered a major punishment in the immediate preceding years. But date-wise, if we see, my lord, the punishment which was imposed upon the petitioner was of withholding
Stoppage of one
in
increment
one
without cumulative.
without cumulative effect, my lord. That was imposed in the year 2008. Now, in the year 2009, the respondents have taken a stand that in the year 2009, an executive instruction was issued, which classified it as a major punishment.
The question is
My lord,
the applicability of the this CCA rules 1965
my lord,
or the CRPF rules 1955.
my lord. The CRPF rules, my lord, London Single Judge has held, does not give the classification of withholding of punishment. Now, it's
That's why only relied upon the this
Executive instruction.
executive instructions
no, my lord, if
while
lordship,
holding that
it can be a
yes, it can supplement if there is no specific provision in the rules, it can supplement.
my lord, now, three issues would come up. One, Rule 102 of the CRPF rules itself says that whatever is not provided for in the rules or the act, it will go back to the CCS rules. That has been also upheld by the Honorable Delhi High Court, my lord. If 102 says that it goes back to the CCS rules, CCS rule provides that withholding of increments would be a minor penalty.
Therefore, the executive instruction to overrule 102 referring to CCS rule, well, that in my humble submission was not permitted. That is the first, my lord. Second,
That you have not even argued before the single.
my lord, that 102.
That point has never been
But
raised.
102 perhaps, because executive instructions which was brought on was not part of the pleading, my lord. It was just placed at the time of hearing. Therefore, my lord, 102 perhaps did not get the notice of the then arguing counsel or the honorable court, my lord, it could not have been placed. But that is the position in law, my lord. 102 could take it back to CCS. Second position that, my lord, I would like to insist is that the Honorable Supreme Court has held that if there is a punishment which is withholding of increment without cumulative effect, it has to fall in the realm of a minor penalty.
That's right.
Thirdly, my lord, the punishment having been imposed upon me in the year 2008, later being classified as a major penalty in 2009,
At the time of consideration of your case for promotion.
then it was a case of major punishment. Had I any inkling that this minor punishment would become a major punishment at the point of time?
In fact, this
Because-
punishment was in lieu of dismissal of service.
My lord, yes, but it was taking a very lenient view, giving me a lighter punishment. The intent was itself to give me a lighter punishment, which falls within the realm of a
But
minor penalty as on that
the
day.
another problem is,
My
that
lord.
even if we pass any order in your favor that promote him from so and so date,
My lord,
then those affected persons are required.
my lord,
That is the, again, a problem.
my lord,
Without hearing them,
my lord, I would say is, even if I am now given a promotion to the ASI from that day, there are certain periods of mandatory field service that I would always require to be considered for the next advanced career advancement. Without that mandatory field service and the mandatory training periods, I would never have the chance to go for the next higher rank.
it's altogether different.
And it would only
It
be,
is
my lord,
whether you are completing that mandatory period or not, that is another, that is a question of fact, and that has to be taken, that is to be taken into consideration if your case is considered for further promotion.
my lord, yes.
But here the problem is, if now we pass any order in your favor,
My lord,
then certainly that would affect the seniority of the other persons who have been promoted way back in the year 2015 or 16 or
my
whatever.
lord, yes.
Without hearing them, whether such order
My
can.
lord, could it be a so position that if the honorable court finds that I was entitled to a promotion, I be kept at the bottom of the seniority list below my juniors even of that batch?
That's.
Because, my lord, what I lose out is when I go for my retirement, which is coming in a year or two, maybe now. If that happens, I lose out on everything that. Since it has fallen from lordship that the relevance of rule 102 was not brought to the notice of the honorable court, my lord, in the single bench.
It was not there.
My lord, then perhaps if it is now brought to the notice, there might be a. But
Case of
then
review.
it would have been a case for a review then, my lord.
That's,
In a hurry, the appeal, it was my mistake, I came up with an appeal.
that's the whole thing.
My lord, my lord, could I just say that perhaps if I can go for a review without affecting the previous, because the writ petition was filed immediately after I had been denied my promotion. There was no gap in between.
I understand that.
And at that point of time, promotion.
There's no doubt about that, but the problem now is that
It's-
first of all, this argument was not raised regarding
it-
102.
what happened is, my lord,
And the another question which is troubling us, that without making the affected person,
Because, my
the
lord,
persons
when-
who were
when
promoted
we had
prior
moved-
to you,
when we had moved
without
the,
making them, it's better you go for a review, we'll keep this appeal pending,
my lord,
and you file a review before the
with the appeal pending, my lord,
the appeal is pending.
if that but is going, I'll try for a review.
appeal, withdraw this appeal with liberty to approach and again, if the order remains the same, you can very well again file we'll grant you the liberty.
Otherwise, the other persons are not. Parties
And,
only because of.
after attempting to argue the matter for quite some time, the counsel for the petitioner has submitted that as a matter of fact. The as a matter of fact, while as a matter of fact, at the time of final hearing of the writ petition before the learned single judge, the counsel for the petitioner failed to brought into the notice of the court the provisions of section
Rule 10.
Rule 102 of the CRPF
Rules
1955, which clearly indicates that in the absence of any categorization of punishment, or what is the exact language?
My lord, they say in respect of matters for which no provision is made in this rule.
Which clearly provides that in respect of
Matters for
matters
which no provision is made.
for which no provision is made under the CRPF rules 1955,
They shall be the same. They shall be the same
they shall be the same
as are for the time being applicable to other officers of Government of India.
as are applicable to the other officers of Government of India. It is submitted that as per the Rule 102 CRPC, Rule 102 of the CRPF Rules 1955, the provisions of Central Civil Services Classification and Control and Appeal, in bracket Classification, Control and Appeal Rules 1965 would be applicable. Also, and it counsel has submitted that in the above facts and circumstances of the case, the petitioner, the appellant be permitted to withdraw this petition with liberty to file a review petition before the learned single judge. Full stop. Learned counsel for the respondent has no objection if such liberty is granted. Hence, this writ appeal is dismissed as withdrawn with liberty to with liberty to the appellant to approach the learned single judge by filing a review petition. Needless to say that if any adverse order is passed against the appellant, he can file writ appeal against the same.
I'm obliged.
Item 7.
May it please your lordships. Lordship, this matter, the petitioner, the appellant, was an applicant for the post of Gao Pradhan. And his father was a permanent Gao Pradhan. And thereafter, during the illness of his father, he was appointed as a temporary Gao Pradhan to, not a Gao Pradhan, but to carry on the functions of Gao Pradhan as his father had applied for leave. So for 3 or 4 months, he had done that. And after the death of his father, there was an advertisement for filling up the post of permanent Gao Pradhan. Now, therein he had applied. And we had submitted certain documents as required by the advertisement. Now, the issue was that we were not called for the interview. And at that stage, we approached this court. And Lordship,
You're disputing your age or date of birth.
date of birth, yes, date of birth, and we had
Date
submitted.
of birth in your this school records is recorded as 1993, whereas you are claiming that my date of birth is 1990.
1990. So we had submitted both the documents, as even in their affidavit, they had admitted that.
Unless that certificates indicating your date of birth as 1993 is changed or modified, how can the court can come to the conclusion that no, this is what your date of birth is? In your higher secondary school, by graduation examination, everywhere the date of birth is 1993.
Lordship, actually, only in matriculation certificate, the
Even if
date of,
the date of birth was wrong,
yes.
any person having a wrong date of birth in the affidavits certainly will take steps to get it changed at a first opportunity. Not after this, applying for this and then you say, "Yes, my date of birth is wrong, sir."
That's right. He would have, and he should have actually corrected the, applied for correction of the.
If that is, date of birth was wrong, then
Yes.
we have taken benefit of that, whatever the date of birth for, might have been for this education qualification also.
Now, Lordship,
You can very well take this advantage for seeking government employment or any other thing also.
that's right. Now, Lordship, only my submission, very humbly, most
Yeah.
respectfully, my submission would be that the birth certificate, the class 10 certificate, and an affidavit clarifying that my date of birth is as per the birth certificate. These three things were submitted. Now, of course, Lordship is not convinced, but there is, and
Class 10 certificate, 1993, graduation certificate, 1993, all other documents, 1993. Now you are claiming that my date of birth was 1990. Can't be. Simply on the basis of a this
birth certificate.
birth certificate. Yeah, no doubt about that. That is also that can also be considered. But you have to prove for that this date of birth in your school record was not recorded by your parents, by some stranger or some other person who was not having any knowledge about your date of birth. These are all the things which you have to prove.
Then, Lordship, I'm just providing, of course, it's a division bench of the Punjab and Haryana. It's not binding on Lordships, but it was
Even you refer to one Supreme Court judgment.
yes,
That is also there.
Case.
But that would not help. That case was of service record. There was
Yes,
some
service record was
interpolation in the service record, and in that case, the Supreme Court has observed this. But here, not in this case, where the things are very clear. Sorry, hard case. Yeah. This writ appeal is filed by the appellant, being agreed with the order dated 9/8/2022 passed by the learned single judge in writ petition number 5115/2022, whereby the writ petition filed by the petitioner has been dismissed. Full stop. The appellant has been dismissed in place of petitioner. The appellant applied for the post of Ram Barua of village Kaupati Gaon, full stop. When the appellant was not called for interview, we approached the court with the plea that the respondents are treating petitioner, they are treating the appellant underage for appointment on the post of Gaon Barua. Full stop. It is contended by the appellant before the learned single judge that the minimum age required for appointment on the post of Gaon Barua is 30 years, and the 30 years as on 1/1/2022, and as per the birth certificate of the petitioner issued by the municipal authorities or what?
by the Registrar of Birth and Death.
By the registrar of birth and death. The date of birth of the appellant was 88, the date of birth of the appellant is 8890, and as such, on 1/1/2022, the appellant was above 30 years of age. It is contended that the respondent authorities have not considered the candidature of the petitioner, of the appellant as, and has not called him for interview, treating the age of the appellant as, the date of birth of the appellant as 10/2/1993 and 10/2/1993. It is submitted that the respondents have concluded that since the date of birth of the appellant is 10/2/1993, he had not completed, he had not, he is less than 30 years of age, and therefore is not qualified for appointment of the post of Gaon Barwa. Full stop. The learned single judge, after taking into consideration the fact that in the class 10 board examination and the other documents pertaining to the petitioner, pertaining to the appellant, the date of birth of the appellant is recorded as 10/2/1993. Full stop. It is observed by the learned single judge that until and unless the date of birth of the appellant in the educational certificates is changed by a decision of the civil court or the competent authority, it cannot be treated that the date of birth of the appellant is different than 10/2/1993. Full stop. Having heard the learned concept of the appellant and after going through the material available on record, we don't find any illegality in the improved order, hence this writ of dismissed.
Obliged. Item 8.
My lord, this matter pertains to discharge of service from the Assam Rifles. The Assam Rifles, my lord, they otherwise follow the Central Civil Service Pension Rules of 1972. And as per Rule 48, my lord, there is a provision in the CCS rules that upon completion of 30 years of service, a person in public interest can be discharged from service with 3 months' notice.
But now you have completed the age of 60 years. By this time.
Not yet, he has not yet, my lord.
Yes. I think so, you have completed. In fact, in 2017, you have completed 55 years. 17.
In 17, my lord, he was 47, my lord, as per the affidavit,
47.
my lord. Your lordship looks at page
So
31.
47, he was, since he has attained the age of 55 years, therefore he was compulsory retired.
It is 30 years of service, my lord, not 55. 30 years of
30
service.
years of
30 years of service, my lord. Now, the core issue, my lord, here is that in 2015-16 onwards, my lord, this problem started. Assam Rifles started to use this Rule 48, and some people were discharged on medical grounds. As far as medical grounds is concerned, my lord, Sunil Kumar Sani was a case that was decided by this court and upheld by the apex court. The principle that came out thereafter is that you have to be given a chance to represent against that medical board's finding, and only thereafter a decision can be taken to discharge.
But here.
Here, my lord, it's a question of ACR. As far as ACR is concerned, my lord, our court, my lord, that Guwahati, my lord, now has taken a view that since it is a compulsory retirement, therefore the question of any notice otherwise is not required, and therefore Devdutt's case was distinguished, my lord. Whereas on the contrary,
The case was distinguished while taking into consideration other decision of the
my lord,
same strength of the Supreme Court.
my lord, my lord.
Yes.
And whereas in Meghalaya High Court, what has happened, my lord, the division bench said that, no, you have to give a notice. An opportunity to, my lord, file a representation against the uncommunicated ACR. So in Meghalaya, my lord, following the division bench judgment, everybody who has gone in that jurisdiction, my lord, they are being given and some people are being also have filed an additional affidavit. These people are also being taken back, my lord, upon consideration of the representation against the ACR. So there are two divergent views, my lord, that have come now.
Those Meghalaya judgments.
The Meghalaya judgment is that, my lord, page 117, my lord. Annex of 4, 117, Union of India versus Joseph case. It's ordered by the division bench. In fact, Meghalaya also discusses this compulsory retirement cases like Vaikuntha Das.
There are two judgments.
My lord, the division bench judgment is in the writ appeal itself, page 117. Following which, my lord, I have filed an additional affidavit that this judgment has been followed in other cases also, based on which orders have been also issued by Assam Rifles in compliance, my lord.
That has been taken note of the earlier at the time of hearing on the last date, na?
My lord.
And where is the judgment of our court?
My
This this present judgment.
The judgment impugned, my lord, is that,
No, judgment impugned is that is there.
my lord.
No, you referred that there are two contrary decisions, so another division bench judgment is here or no?
No, no, there is no division bench judgment. From
This judgment is there.
only by Justice Sudan, which is before your lordship now in appeal.
What is your response to Mr. Who is appearing for the respondent? Yes, ma'am. What is your response to this? That pursuant to this Meghalaya High Court judgment, the people some similarly situated, some rifle personals have made representations and they were appointed. Again,
Lordship, that exactly on that point, I have no instruction that whether it will
last
be,
occasion, madam, this was
Yes,
the
Lordship.
order.
My lord.
because Lordship, in,
1/8/2020.
Yes, Lordship.
This
Yes,
was the order, it drawn attention of so and so. The further state, some rifle being employer has complied with the direction given, he is further submits a few more judgments rendered so and so. He may bring these facts on record through an affidavit so that the learned counsel can take instructions and respond.
Lordship.
So
That,
what is your response to this? They've already filed additional affidavit.
yes, Lordship, they have filed the additional affidavit. I have sought for instruction also, but not, but one more thing, Lordship, that main point is that adverse entry, that was not communicated, Lordship, but that was not their plea in the writ petition. Subsequently,
Was the only plea.
no, in the writ petition, Lordship, that plea was
That
not
was the
taken.
only plea.
In the
What you are
judgment also,
saying?
already in the judgment it there, but in their writ petition itself, it was not there.
Once the learned single judge has taken into consideration whatever their arguments and dealt with it,
Lordship.
even though if he has taken this ground or not, why to go into all these technicalities? The learned single judge has decided the writ petition purely on this premise that even though if the adversary
Yes,
has not
Lordship.
been communicated to him, that would not has any bearing on the matter.
Because the Lordship,
That was the case.
single judge has found that the decisions that were cited by the respondents were more.
But that's right.
Okay.
That maybe we may also concur with this or we may not concur. But ultimately, once the court has given you a direction to complete your instructions, get in pursuant to the order passed by the Meghalaya High Court, you acted upon that and considered their representation. And again, those persons were inducted into service. What is your response to that?
Because there cannot be two contrary, my lord, set of rules applicable for
Maybe
different
even
persons.
if they have any case, it may come with the case that there are 2-3 more judgments are.
Meghalaya High Court, there are some judgments.
Judgments
that-
that,
yes,
have
Lordship.
you complied with those judgments?
My lord. The compliance orders are also filed, my lord, in my additional affidavit.
What is your response?
Lordship, Harbels
Take
are,
your instruction.
Lordship,
We may permit him to file an affidavit.
Lord.
Then file an representation, consider his representation also in the light of the about decisions taken.
Lordship may kindly take it after immediately after application. I will a specific instruction whether it will be applicable here.
Pursuant to the direction given by this court on 1/8/2023, an additional affidavit is filed on behalf of the appellant on 27/2/2023, stating that pursuant to the orders passed by the division bench of the Meghalaya High Court and also by the single bench of the Meghalaya High Court, in many cases, the Assam Rifles have considered the representation of the employees who have been compulsorily retired and again retain them in service. Stop. No counter to the additional affidavit dated 27th of September 2023 is filed on behalf of the respondents, counsel for the central government, by the counsel for the central government. ये B. Sharma, Ms. B. Sharma, Central Government Council seeks one last opportunity to respond, to file a response on behalf of the respondents to the affidavit filed on behalf of the appellant on 27 September 2023. Full stop. Last up, 12 cents so list on 23rd of July.
Apply.
Bibliography.
Item 9.
Meeting law. In this case, Lordship, advertisement for the various colleges in assistant professor was held and in direction of the DSC. In this advertisement, it has been held as per the guideline dated, so and so it will be held. But due to the admit, some post are interview conducted by my post has been and along other has been left out. There some administrative reasons.
Your qualification is?
My qualification is Lordship. I am a MSc, MPhil, PhD, Lordship.
Your qualification?
Lordship, my qualification, Lordship, page number 25, Lordship. I am a master degree holder in chemistry subject, obtaining state degree from Guwahati University, 2006. He is also MPhil and PhD degree holder. Page number 25, Lordship. Direct singular lordship, others held my favor in my favor. Lordship, only one line lordship. Please do this point, lordship, page number, lordship.
Yes, that is there.
Lordship,
How is it?
lordship, that was the, I have proved this, then lordship had asked how you asked for this.
Yeah.
Yes, lordship. Then what happened? Earlier, the OM, which was doing the advertisement, it was in accordance to the UGC guideline, and there was a marking pattern. Lordship for academic performance and research performance and interview performance. The marks were less. But when new guideline come, interview part was totally exhausted, lordship.
By the UGC.
No, by the this,
By them.
by them,
them.
not the UGC.
And they assigned some mark for the NCC and.
And so yeah, I have no objection, lordship. But in my research paper publication, mark has been curtailed. Earlier is for research paper because I am a PhD holder. I have to research paper 10 marks was there, but new guideline 5 marks has been given, so my research marks has been curtailed.
What about the other these connected petitions decided?
Connected distribution is decided, lordship, along with
What happened in those?
those they have got appointment, lordship,
Huh?
but they have got some got appointment in another. They are not interested.
Only this one.
Only this, lordship.
Only one opinion.
Only one application, lordship. Then, lordship, what happened, lordship? After this, lordship,
The
the
writ petition number is
5578, lordship.
5578.
Lordship. Lordship, interestingly, what happened, lordship, during the pendency of this petition, this selected candidate did not join. He goes to another college, lordship, because
It's another.
but lordship, they are thereafter, lordship.
But your this 5578, in fact, there is no consideration of this 5578 petition in the whole order.
Lordship, 5578, 2020, lordship,
Yes,
WPC.
sir.
No, original to 5578. Oh, my. Rahina 952. एक मिनट से one of 99 59 5578, lordship, page number 92. I am there, lordship.
92. The internal page of the judgment.
Yes, lordship.
Which page?
92 page number.
Internal.
Page number 8, lordship. That's
8.
Top, lordship.
That is there, but the Senate secretary has not discussed the facts of your case.
It is in cost title, but otherwise also it is not discussed in the.
In the judgment, it is not discussed.
Judgment not
The
discussed.
point which you are raising.
Yes.
Here, that has not been even taken into consideration. That this reduction in the mark of the research paper, this point it was not at all raised.
Not, lordship, I have filed affidavit, lordship. That was not considered. Therefore, I have filed affidavit.
Sir, if that has not been considered, then approach the learned single judge by filing a review petition, sir.
Lordship,
Once this issue which you are raising, because the learned single judge has dealt with only with the point which was raised that these subsequent guidelines cannot be changed, so and so.
And Lordship,
The learned single judge is only taken into consideration the
Rule of the
when
case
the
cannot.
major change between the earlier OM and later OM was marks allotted to Viva OSE has been done away with. The learned standing council, the segment of Viva OSE earlier allotted was a scope of nepotism. You just see in this para 24, the learned single judge will observe this. This point which you are raising was not even touched by the learned single judge.
Lordship, yeah, Lordship, in my common affidavit, Lordship, it has been raised, Lordship, but it was not
Then-
considered, Lordship.
Even Lordship,
It is.
paragraph 3 onwards, Lordship, Honorable Single Judge Lordship discuss up to paragraph 11, Lordship. The petitioner's case was, there is no
Not even considered.
Lordship.
Sir, para 42
Lordship.
of the judgment,
Lordship.
the issue which arises for determining whether the department is holding the selection as per the so and so after advertisement and so and so. Para 44 more elaborate here.
Lordship, Lordship.
The office memorandum in question governs the allotment of the purpose of selection as in various colleges. The discernible change of the office memorandum, which was existed at the time of publication of the advertisement, and the one which came into operation by the time when the interview was held, mainly marks allotted to under the head for interaction with the selection committee.
Lordship.
The OM dated has allowed 5 marks of for the said head. It
Right.
is needless to say the said 5 marks subjective in nature and left to the total discretion of. Once the concept of discretion, there is a bias or nepotism can be totally ruled out from the public perception. The conscious decision of the government to remove the said aspect was delete the 5 marks and include 3 marks NCC certificate holder, 1 mark, 3 mark for NCC certificate holder, 1 mark gold medal in a university youth festival so and so and representing the state Olympic event and 1 mark so and so. This is what the negligible change in the so and so also made since the so mistake so and so so and so. What you have said, research paper and all, this was not at all considered or raised.
Consider, Lordship, please this point, Lordship, kindly see 49 page number, page 49.
But the learned single judge has taken into consideration only the change in respect of this interaction with the selection committee.
Lordship,
There is no discussion about this. That
Lordship,
earlier the research paper,
yes,
how many
yes,
marks were awarded for that?
earlier 10,
And now,
5.
sir, you have not even raised and discussed.
In my affidavit, Lordship, I have raised, Lordship, but
You might have filed in your affidavit, but your case was not at all considered.
not at all. Therefore, I have
You have to file a review petition for
Lordship,
that.
Lordship, and liberty may be given, Lordship. Otherwise, I am top, Lordship. If that much something, I will top.
Itu নাই তুমি কোৱা নাই একদম আৰু তুমি ডিসকাস নহয়
নহয় হেৰিটো তাতে
অৱস্থাটো আছে তেওঁলোকে মেইন
আৰু গোটেই কেইবিলাক একেলগে ডিছকাছ কৰি দিয়ে এটা পাৰ্টিকুলাৰ কেছ হিচাপে চাব লাগিব।
This writ of appeal is filed by the appellant being aggrieved with the judgment and order dated 9/3/2022. The judgment passed by the learned single judge in writ petition number 58/2021 and other connected writ petition, including the writ petition filed by the appellant in place of, including the file writ petition number 5578
Lordship,
5578/2021 filed preferred by the appellant. Full stop. Learned counsel for the appellant has submitted that the principal ground raised in the writ petition filed by the appellant is regarding the change, regarding the reduction of marks under the head of research and
research and publication.
research paper / article publication
Lordship, and MPhil Lordship, and MPhil degree Lordship.
and MPhil degree
Length and experience Lordship.
from 10 to research paper / article publication from 10 to 5
Lordship,
and
MPhil degree.
for MPhil degree and
MPhil degree 3 to 2. MPhil degree advanced 3. Then
and for MPhil degree from 3 to 2
and experience Lordship, earlier experience 3.
and experience and the reduction in the marks under the head of experience.
Three to and Lordship, marks in
It is
high
intended
secondary
that
B and MA Lordship. Other marks are also there.
specific affidavit is filed on behalf of the appellant in the writ petition, but the learned single judge has not dealt with the same in the judgment dated 9/3/2022. Full stop. The concept for the appellant has therefore prayed that he may be allowed to withdraw this writ appeal with liberty to file and review petition before the learned single judge, dismissed with liberty as prayed for.
Lordship, page number 61. Lordship, other marks is also there. Lordship, high secondary.
And various other and reduction in marks in various heads.
Lordship.
साथ में add करते हैं. That we have a reduction from this 10 to 3 and 3 to 1 and reduction of marks under the various heads.
Lordship. Obliged.
May I please your lordships? I am sorry to say lordship, this will be still praying for some accommodation because they have some workload, pending workload lordship. They could not provide us the necessary instructions.
You have to file affidavit.
Yes, lordship, they could not provide us and a letter for paying some accommodation lordship.
How much?
They have not set any time frame lordship. Let it be fixed on 22nd. Our learned senior friends agreed to that.
22nd
of July.
Convenient.
Wait.
So, we have asked for the record.
Record has come.
And yes, government of Assam is also directed to file an affidavit.
That possibly they are seeking time.
That is, by what date you will file the affidavit?
I shall try on 22nd, before 22nd.
This court wide order dated 30th of May 2024 directed the counsel for the government of Assam to file an affidavit on behalf of the state. The clarification of the state clarifying its stand on the point involved in the writ petition. Full stop. Then the counsel appearing for the government of Assam prays for granted some more time to file affidavit. Full stop. Taking into consideration the above facts, taking into consideration the prayer made by the concept of the plan, last opportunity is granted to the council for the state of Assam to file affidavit pursuant to the direction given by this court on 30th of May 2024 by 18th of July 2024, while serving an advance copy to the council for the petitioner as well as the respondents. This matter on 22nd of July 2024. 22nd. 22nd of July. 22nd of July 2024. And it council. 24th. 24th, okay, 24th. And council for the Silchar Municipal Board. Waiting the records. We shall keep the record ready on the date of the, on the date of next hearing.
For hearing, item 225.
The next.
My lord, in compliance with the earlier order, my lord, we have filed the affidavit today, my lord. It is yet to be taken with the.
Page 140.
Para 4.
Service rule. No. 98,
98, 37, 30, yeah, 5, 6, and 7, 30.
No, first page to first page to 33. Relevant page no?
35, method of
35.
36.
37. Are you to about it? Give me a definition. 143. No, so recruitment by 9. Rule 9 में क्या बताना चाहिए? Shall be final. Rule 8, 47. Rule 8 is important.
Yes.
Direct recruitment को भी जा होगा. Rule 16, 150.
When you come to say yes, okay.
Complete नहीं है ना? Complete नहीं है ना? Mail is বুঝে পেয়েছি মানে মেইনলি করে আছে তো
Have you received the copy? Yes. My lord, we have an answer to that. In fact, the rules itself provides the answer. Rule 8 of the, my lord, this 1989 rule, under which the examinations are being held. It says once the list is published by APSC, that's final. State do not have any say. State have a say only with regard to, my lord, once recommended candidates are placed before the government. Regarding police verification and health part, the state can say. And all throughout, my lord, they never.
Counter for this will consider.
We'll file a counter. Or she can have the matter immediately on reopening, my lord. We'll file the affidavit.
If you could have persuaded the state government, then it would be easy for.
Then it would have been more easy, my lord. Now, even now, we have not lost hope, my lord. Hopefully, we can persuade your lordship.
Additional affidavit is filed on behalf of the state, clarifying its design in respect of the recommendations, in respect of the strength of the APSC. APSC, Assam Public Service Commission. Stop. And it council appearing for the appellants takes some time to file counter to the affidavit filed on behalf of the state. This matter on 17th July, 17th of July. April.
I'm getting, I think, because he said in what? They have not filed anything in our map. But we rely on it, then we should also file a reply.
It's a stand of the state government that
Stand
they
is
not
same.
consider. So
We may also file. We'll serve.
you are in receipt of this affidavit?
Yes, we got a copy of it.
So you file in the reply.
Similar stand in all the appeal.
18th of July. 18th.
अच्छा ओरिजिनल एफिडेविट के नाम है लोग चलो कॉपी को मंगवा कॉपी भरा दी
Item number 7 to 11.
May please, Lordship. Before on the last occasion, Lordship, sir, had requested us that we make a chart of the allegations.
Yeah.
I have concluded my arguments. We have filed a separate volume, a in the spiral volume. That is with respect to Gwalpara and Dibrugarh.
These are the written submissions.
Yes, and at page 167
167.
of that's the last page of my written submission. In fact, for the convenience, we have also put the case laws and everything that we are relying. This is with respect to Gwalpara and Dibrugarh. If I may just place it, Read appeal, Gwalpara is the appellants were appointed by Joint Director of Health Services, Gwalpara, who according to the state is not the competent authority as contemplated within the meaning of section 2A of the Assam Public Service Direct Recruitment of Class 3 and Class 4 Post Rules 1997. The second was there is no approval of the Director of Health Services, Assam. And number 3 is no SIU approval from the government. And the same thing is reflected in respect of Dibrugarh. And these are as per the final show cause notice that was issued to us.
These are the final show cause notice.
These were the charges that we were told to explain. We have noted allegations against the appellants as per the show cause. If Lordship will recollect, my thrust of the argument was that this cannot be illegal.
Illegal.
But at best could be irregular. And I demonstrated why, and also Lordship had placed reliance on Siraj Ahmed.
Reliance on?
I placed reliance on the three-judge bench judgment of Siraj Ahmed, which says, which amalgamates the ratio of ML Kesari and Uma Devi. And if Lordship will kindly have a look at my written submissions,
yes,
which starts at page 1, I will briefly. My first submission was the appointments of the appellants can at best be termed as irregular and not illegal. That I have explained, Lordships. If Lordship at page 1 of my submissions.
Yes.
In the present case, substantial compliance with the constitutional scheme, as also the rules have been made, the appointment of the appellants can at best be held to be irregular. It is certainly not illegal. The alleged irregularities, as pointed out by the learned single judge at para 77 of the impugned judgment, do not have any relevance for the assessment of merits of the candidates who were appointed. It is not the state's case that the appellants were ineligible for appointment. Hence, the learned single judge was wrong to quash the appointment of the appellants herein. And in support of that, I had placed Siraj Ahmed, Lordships. If Lordship would like to have a look at Siraj Ahmed once again, I can place it, Lordships.
We already gone.
Okay. Number 2, as regards the second issue regarding SIU approval, it is submitted at the office memorandum bearing number so-and-so dated 4/7/2005, issued by the Government of Assam Finance Budget Department, clearly states that the requirement of SIU approval was given effect from 21/7/2005. The aforesaid OM was not in existence at the time selection process commenced, which is 3/1/2005, that is the date of advertisement. Hence, the same cannot be retrospectively applied to the disadvantage against the appellants. Alternatively, it is submitted that the very fact that the appellants have been drawing their regular salaries for 14 long years would in itself indicate that there was a deemed approval by SIU. It is not the respondent's case that a SIU at any point of time opined that the posts to which the appellants were appointed are not required and are to be abolished. My third submission under this heading is the appointments.
Mr.
Yes.
Finance.
State staff inspection unit.
Staff inspection unit.
Yes, Lordship. Staff inspection unit.
Finance. Yes.
Yes, Lordship. The appointments made by the joint director is legal and sustainable. He is the appointing authority as contemplated within the meaning of section 2A of the Assam Public Service Direct Recruitment of Class 3 and Class 4 Post Rules 1997. There is no specific rule indicating that the advertisement cannot be issued by the Joint Director of Health Services and or the authority is authorized to issue the advertisement. As such, advertisements so issued by the Joint Director of Health cannot be termed to be unauthorized. The fact that the Joint Director of Health Services is the appointing authority qua the appellants is fortified by the fact that it is the same authority who issued the impugned termination letter. The appellants rely on the following documents. Judgment, we are relying on this 22/5/2022 letter from Director of Health Services indicating delegation of power to appoint to the respective Joint Directors of Health Services. That is at page 1124, Lordships. The second we were relying on is the impugned termination order dated 28/10/2019 from the Joint Director Services Assam, which Lordships can find at page 1013. And with respect to the proposition that it is if the appointing authority and the terminating authority are coextensive powers. With respect to that, we are relying on 1984 SCC 592 para 9. Of course, this judgment, Lordships, I could not place it last time. Would Lordship like to have a look at that? If Lordship so desires.
It is in the compilation.
It is in the compilation, Lordship. Every judgment that I'm relying is in the compilation, Lordships. We are relying on para 9 of that. 1984 SCC 592.
Which is a page?
Lordship, page, I will tell you. 20 of my compilation. And at page 22 is para 9 of my compilation. May I be permitted to place that paragraph, Lordship?
Yes.
Page 22 of the compilation, Lordship, para 9.
The question
is whether the expression appointments used in the government order dated so-and-so will include termination of service or compulsory retirement from service also. It is a fundamental principle of interpretation that unless a contrary intention appears from the context, a power to appoint should also include a power to terminate. The appointment, including termination of the person appointed by his compulsory retirement in accordance with the terms and conditions of his service. This fundamental principle underlies Section 16 of the General Clauses Act. In other words, the power to terminate the appointment by compulsory retirement or otherwise is a necessary adjunct of the powers of appointment and is exercised as an incident or a consequence to that power. And in Lordship, in this case, we were appointed by the Joint Director, we were terminated by the Joint Director. So the appointment order and termination order is a record, Lordships. Now, my second proposition was no fault can be attributed to the appellants in the matter of their appointment. I'm sorry.
Yes.
No fault can be attributed to the appellants in the matter of their appointments. There is no allegation of any wrongdoing or unfair practice or fraudulent activity committed by any of the candidates' appellants, and as such, the said selection was not vitiated by malpractice. There are no allegations of any mala fide either. It is also to be noted that there is no challenge by any unsuccessful candidate alleging corrupt practice and fraudulent activity resorted to by the appellants. The appellants have been serving for almost 14 years until their services were terminated in 2019. They have been drawing regular salary ever since the initial appointment without any break. This in itself is a strong factor indicative of the fact that their appointments were above board. To remove them from service at this stage of their life will cause immense financial burden and emotional hardships to them. It is in this regard, it is submitted that Rule 14 of the Assam Public Services Direct Recruitment of Class 3 and Class 4 Post Rules 1997 empowers the state to relax the stipulation of the rules in appropriate case. This is one such appropriate case. In this regard, Lordships, I had placed 2013. On the last occasion, I had placed that in such circumstances when the candidates were not at fault, what did the Supreme Court do? They saved those appointments, saying that it would not be in public interest. And the last judgment, which is one lordships. The latest judgment on this point is 2024 2 SCC 269. May I just place that, lordship? It may be necessary to place that. Page 36.
Yes.
Vivek Kashisht. Would lordships come to straight to page para 43? I will tell you the lordship, here the background is of appointment of judicial officers.
Para 43, page 60.
Para 43 is at page 60 of the compilation, lordships. Page 60, lordships. Para
Yes.
43. Having gone through the, my lord Justice Shamli, having gone through the pleadings of the appellants and that of the respondents, we are of the considered view that there has been a violation of the process in making selection appointments of the appellants, inasmuch as the vacancies on which the appellants were appointed were never advertised. And strictly speaking, these vacancies cannot be termed as anticipated vacancies, for the simple reason that these vacancies were only created on 18/4/2013. That is after the selection process had begun and the advertisement was issued on 1/2/2013. What is also important for our consideration at this stage is that the appellants in the present case have been working as judicial officers now for nearly 10 years. They are now civil judge senior division. These judicial officers now have a rich experience of 10 years of judicial service behind them. Therefore, unseating the present appellants from their post would not be in public interest. Ordinarily, these factors, as we have referred above, would not matter once the very appointment is held to be wrong. But we cannot fail to consider that the appellants were appointed from the list of candidates who had successfully passed the written examination and viva voce, and they were in the merit list. Secondly, this is very important. Secondly, it is nobody's case that the appellants have been appointed by way of favoritism, nepotism, or due to any act which can be remotely called as blameworthy. Finally, they have now been working as judges for 10 years. There is hence a special equity which leans in favor of the appellants. In a recent Constitution Bench judgment of this court, in Shivanandan City versus High Court of Kerala, though the finding arrived by this court was that the rules of the game were changed by the High Court of Kerala by prescribing minimum marks for viva voce, which were not existing in the rules, and therefore, in essence, the appointment itself was in violation of the rules. Yet, considering that those persons who had secured appointments under this selection have now been working for more than 6 years, it was held that it would not be in public interest to unseat them. It was stated in SCC para 55 and under. The question now which arises before the court in this regard to the relief which can be granted to the petitioners. The final list of successful candidates was issued on 6/3/2017. The candidates who have been selected have been working as district and session judges for 6 years. In the meantime, all the petitioners who are before the court have not functioned in judicial office. At this lapse of time, it may be difficult to either direct the unseating of the candidates who have performed.
This direction is under Article 142, para number 46. And in relation to the district and judicial officers, how can you equate?
No, I have also
class
placed
four employees with the judicial officers.
No, I have also placed the other judgment. This judgment I had not placed last time. The principle. The
142, para 46, they have said this direction they are issuing in 142.
I bow down to that. But on the last occasion, I had also shown a direction which was not related to judicial officers. If Lordship will see that.
Which is that?
Vikas Pratap Singh, Lordships.
Page.
That is Lordships. Page 24 of the compilation.
Yes.
This is para 21 at page 502, which is at para 21. Page 32. Page 32 of the compilation.
Yes.
Shri Rao. Shri Rao would submit that the case of these appellants requires sympathetic consideration by this court, since the appointment of the appellants on the basis of a properly conducted competitive exam cannot be said to have been affected by any malpractice or other extraneous considerations or misrepresentation on their part. The ouster of 26 appellants from service, after having successfully undergone training and serving the respondent state for more than 3 years, now would cause undue hardships to them and ruin their lives and careers. He would further submit that an irretrievable loss in terms of life and livelihood would be caused to 8 appellants amongst them who have now become overaged and have also lost the opportunity to appear in the subsequent examination. He would place reliance upon the decision of this court in Rajesh Kumar versus State of Bihar, wherein this court has directed the respondent state to re-evaluate answer scripts on the basis of correct model answers, and sympathetically consider the case of such candidates who, having been appointed in terms of erroneous evaluation and having served the state for considerable length of time, would not find place in the fresh merit list drawn after re-evaluation, and directed the respondent state against ousting of such candidates and further that they be placed at the bottom of the fresh merit list. The pristine maxim of frost et jus, nuquam cohabitant, fraud and justice never dealt together, has never lost its temper over the centuries, and it continues to dwell in the spirit and body of service law jurisprudence. It is settled law that no legal right in respect of appointment to the said post vests in the candidate who had obtained the employment by fraud, mischief, misrepresentation, or malafide. Then they have relied on such judgments. It is also settled law that a person appointed erroneously on a post must not reap the benefits of wrongful appointment, jeopardizing the interests of the meritorious and worthy candidates. However, in cases where a wrongful or irregular appointment is made without any mistake on part of the appointee, and upon discovery of such error or irregularity, the appointee is terminated, this court has taken a sympathetic view in light of the various factors, including bona fide of the candidate in such appointment and length of service of candidate after such appointment. And thereafter, it goes on to save these appointments, lordships. At para 28.
Yes.
Para 28 is lordships at page 35. In our considered opinion, the appellants have successfully undergone training and are efficiently serving the respondent state for more than 3 years, and undoubtedly their termination would not only impinge upon the economic security of the appellants and their dependents, but also adversely affect their careers. This would be highly unjust and grossly unfair to the appellants, who are innocent appointees of an erroneous evaluation of the answer scripts. However, their continuation service should neither give any unfair advantage to the appellants nor cause undue prejudice to the candidates who are the revised merit list. Accordingly, we direct the respondent state to appoint the appellants in the revised merit list, placing them at the bottom of the said list. The candidates who have crossed the minimum statutory age bar for appointment shall be accommodated with suitable age relaxation. That was the final direction the court had given. And this principle has been followed continuously, lordships. Because this is not a case where there is any allegation for us. We were appointed through a selection by an advertisement against substantive vacancies, lordships. Yes. Now, the learned single judge has relied on a judgment to non-suitors. We have tried to distinguish that it doesn't apply. Would lordship kindly see para 6 of my written submission? If lordship come back to para 6. Page 2. Page 2. The law laid down. The law laid down by the Honorable Supreme Court in State of Bihar and others versus Devendra Sharma, that is 2020-15 SCC 466, is not applicable to the facts and circumstances of the instant case. This is a case where large-scale appointments were made on the basis of forged appointment letters and forged educational qualification certificates. Further, the appointments were not made against valid sanctioned posts. Another factor that weighed with the Honorable Court was that the appointments were made by a person not competent to do so as per Chapter 1 of the Bihar Health Manual, which stipulated that the Director of Health Services was the appointing authority. These facts will be evident from a perusal of para 17 onwards of the judgment. It is submitted with respect that none of these facts and circumstances arise in the present appeals. Therefore, reliance placed by the learned single judge in the above judgment is perhaps wrong. We are trying to distinguish this judgment, because none of the facts which weighed with the Honorable Supreme Court are prevalent in this case, Lordships. There are no allegation of fraudulent activity or otherwise.
There was an advertisement, there was a second party. ডিপার্টমেন্টে পড়ায় পাইছি তো আমি অ্যানেক্স করেছি ডিপার্টমেন্ট
On the last occasion, Lordship had shown the advertisement, had shown the select list that was drawn up.
Where is that?
Yes, Lordships. If Lordship will come to my writ petition, Narayan Rabha.
Narayan Rabha.
Yes, Lordship.
Yeah.
Lordships, the appointment, the advertisement is at page 163, 164. Yes, 163, 164. And this is an advertisement published in a newspaper.
163.
Applications are invited in standard form as published in Assam Gazette Part 9 for 70 posts of grade 4 under the establishment of Joint Director Health Services Golpara in the scale of pay of 24503670 PM plus other allowances as admissible under the rules. There shall be usual reservation for SC, ST, Hills, OBC, MOBC candidates as per government rules, educational qualifications. Applicant must have read up to class 8. Age candidate should not be less than 18 years and not more than 36 years as on 1/1/2005. The upper age limit is relaxable by 5 years for SC, ST plains, ST Hills candidates only. The candidate should apply along with SSS copies of certificates and 1 passport size photograph. Application should reach the office of the undersigned on or before 17/1/2005. And if Lordship will turn over the page, this is published in a newspaper. And these facts have been noted by the learned single judge, that there was a semblance of selection in respect of Gwalpara and Dibrugarh. But it non-suits us on the ground that these were in violation of the 97 rules. Essentially, the learned single judge held 3 factors against us. That is, 97 rules were not strictly complied with. And there was no SIU approval.
There was no
SIU approval. That's and the appointment director health service did not appoint us. These were the 3 things. Ultimately, it was all everything turned around the 97 rules. That there was no compliance with the 97 rules, though our case is that there has been substantial compliance. Now, one non-compliance that the learned single judge said was that the selection committee ought to have been 5-member. In our case, it was a 3-member committee. There's no dispute on those facts. But what's serious, how does it vitiate the whole selections in the absence of any candidate challenging our selections?
No allegation of any malafide or nepotism.
candidate can't challenge the selection if we could, if we would have participated in the selection, he can't challenge that. Candidate challenge.
There are judgments on both sides, Lordships. But here finally our termination order arose, not because there were any allegations, but there was some
inquiry or something.
Yes, that administrative inquiry, which also initially with respect to surveillance workers, which was then extended to us.
So these are the facts in relation to this 7 and 8 number.
I'm sorry, Lordship.
7 and 8 number.
7 and 8.
Writ appeals number 429 and 428.
Yes, lordships.
These
Yes.
are in respect of this.
আমি RTI department.
Your case was not listed. Same.
And more ground I want to add that the deficiency directed by this court, we pointed out to the petitioner. But the government went for a summary proceeding. And our entire case is that the substantive rights under 311 were violated. Because summary procedure, possibly the government thought that we have complied with the principles of action justice, but that is not so. And for that, I additional.
That they have also raised it.
That we also, we have raised it in our submission also. And lordship will kindly take up volume 4. In fact, the select list, we got it from, we applied through RTI to the department and they only furnished us the select list. If lordship will kindly come to page 1171 of volume 4.
He's one of the candidates in the repetition.
And 1172 is the select list.
117.
This is the select list.
Just.
And this is the list furnished to us by the department itself. Post the selection that was held after the advertisement lordships. And similar list is also available in respect of Dibrugarh lordships.
All these documents were available before the learned single judge?
Yes. In fact, lordship, I'll revisit those paragraphs where the learned single judge says, accepts that these, with respect to Gwalpara and Dibrugarh, there is a selection. That lordship, the learned single judge also accepts it. But then non-suits us for non-compliance of the 1997 rules.
Yes, which judgment you are referring to?
Now, lordships, I'll just complete my written submission.
Anything else? Anything else you want to?
I just wanted to complete the written submission. If lordship.
Let him. Let him finish.
So Devendra Sharma, we have seen, sir, lordships. Now I'll come to my third submission, lordships, C. That is at page 3.
Yes.
Neither the show cause notice nor the impugned termination order was issued citing alleged non-compliance of 1997 rules as the reason. A bare perusal of the show cause notice dated 31/8/2019, that is annexure 24, page 647, as well as the impugned termination order dated 28/10/2019, annexure 27, page 1013, will unmistakably reveal that there was absolutely no whisper with respect to non-compliance of the 1997 rules and or that the appointments were illegal as it was made during the ban period. The alleged violation of the 1997 rules in the matter of appointment of the appellants and the appointments were made during the ban period was for the first time set up by the state in its additional affidavit filed where the matter was pending before the learned single judge. This was certainly not permissible inasmuch as the law in this regard is well settled that when a statutory functionary makes an order based on certain grounds, its validity must be judged on the reasons so mentioned and cannot be supplemented by fresh reasons in the shape of affidavits or otherwise. I will not read this judgment. This judgment, we have read it many times.
Page 99, para 8.
That's a page 99, para 8 of the compilation, the relevant portion that I'm relying on.
Because in the show cause notice, they have not cited those reasons.
No reason.
Yes.
And the last was violation of the principles of natural justice. The screening committee report, which formed the foundational material to declare our appointments as fake and was not furnished to the appellants. Despite specific requests, and particularly in light of the previous High Court orders dated 18/5/2018 and 31/7/2019. This has caused serious prejudice to the appellants. A perusal of the impugned termination order would indicate that the detailed reply to the show cause notice submitted by the appellants was not considered by the respondents before passing the order. Hence, this is a clear case of non-consideration of the relevant materials and non-application of mind by the respondent authority. This vital issue has been completely overlooked by the learned single judge, and that portion where the learned single judge considered is at page 1506, para 90, consideration of this issue by the learned single judge. In fact, in our show cause notice, we made a clear request that please furnish us those materials which you are relying on. That was never supplied to us. We took a specific plea, lordships. Yes. So that is it, lordships, and I therefore to sum up, lordships, I'm just relying on these two judgments, which is part of the compilation. I will not take much time. So, lordships, to sum up, it is our very clear case that it's a case of irregularity. Immense hardship would be caused to these people. This is not a state which generates a lot of employment. And these are fourth-grade employees. So, in the facts and circumstances of the case, when there are no allegations of any wrongdoing on our part, lordship will kindly save our appointments and direct reinstatement, because there has been substantial compliance in respect of everything. I am so very grateful. Lordship will kindly just make a I will just not read it. Our reply to the show cause notice is at page 902, volume 4, where we raise this specific issue. If Lordship will kindly have a look for a moment, I'll just read it. Page 902, volume 4, Lordships. Just 2 pages, let me read it so that the whole thing is complete. Page 902, I am reading from the second paragraph, Lordship. Volume 4. Volume 4. Sir. Yes. As per direction of the Honorable High Court by order dated 18/5/2018, passed in WPC 3046/2018, writ petition filed by me and other analogous matters, that is writ petition challenging the same, along with similarly situated persons, wherein the Honorable Court directed that if anyone is found to be non-genuine amongst the serving persons, the authority must, however, indicate the precise deficiency and afford opportunity to the affected employee before any adverse action is taken. And pursuant to the aforesaid direction of the Honorable Court, I had appeared before the screening committee, and as such, the screening committee should have stated the deficiency. And in view of the same, I earnestly request you to furnish me the minutes of the screening committee and the decisions so arrived with respect to my appointment, because non-furnishing of the minutes of the screening committee will highly be unjustified and cause serious prejudice to me. Further, I most earnestly request you to give me 10 more days of time so as to enable me to submit the reply after the furnishing of the minutes of the screening committee. That, sir, in the second round of litigation filed by me challenging the impugned show cause notice dated 10/6/2019 by way of the writ petition bearing number so-and-so, where the Honorable High Court by order dated 31/7/2019 and other analogous matters had also reiterated the directions issued by the Honorable Court in the earlier round of litigation, that is WPC 3046/2018 and other analogous matters. Hence, in view of the same, I most earnestly request you to abide by the directions so passed by the Honorable High Court and furnish me with the findings and decision and or minutes of the screening committee, which conducted several rounds of scrutiny with regard to my appointment. However, without prejudice to the above contention and right to file an effective reply, I submit my reply as follows. The ground assigned is clearly perverse, inasmuch as the same suffers from glaring irregularity. I was appointed in the Health Department as the Joint Director of Health Services, Goalpara, against sanctioned vacant post. And having been drawing my salary against the state post since the date of my appointment, my joining in the service as well as my continuance in the state post would go to demonstrate that the same has the approval of all concerned. Inasmuch as the post is duly sanctioned post, there has been no objection whatsoever was ever raised with respect to my service and drawal of salary by me. Hence, in view of the same, the aforesaid contention does not in any way indicate my appointment to be ingenuine and or doubtful, in as much as my appointment that has the sanctity of law. It is to be noted that I was appointed in person to the advertisement dated 3/1/2005, wherein I participated in the selection process, and at that time when the selection process was initiated, the approval of SIU was not required, and the mandatory requirement of approval of SIU came only with effect from 4/7/2005. So the above contention that there is no SIU approval in my case does not hold good, as I have been drawing salary since the date of my appointment. Further, there is no law which says that the approval of DHS is required and or mandatory, and even assuming but not admitting that the approval of DHS is required, it cannot be termed as my fault. Rather, it's the fault of the authorities and cannot be attributed as my fault. And if there would have been any approval of the authorities as stated, then in that case, I would have not been receiving my salary. Hence, the contentions are baseless and have been made only with the view to harass me unnecessarily for the reasons best known to the authorities. Sir, it is to bring to your notice that the scrutiny so undertaken by the scrutiny committee that were conducted are not transparent, and I have never received minutes of the said meeting or know about the report. Hence, I request you to furnish with the minutes of the meetings of the screening committee as directed by the Honorable Court by order dated 18/5/2018 passed in so and so, wherein the Honorable Court by order dated 31/7 has also reiterated the same and directed the furnish the affected candidate with a precise deficiency and afford opportunity to the affected employee before any adverse action is taken. This was not done, Lordships. As a matter of fact, this was not. Nothing was, but
so the earlier 2018-19 petitions were filed by all the petitioners or all the appellants or some of them?
Some of them, Lord. On instructions, I'm saying with respect to my set of appellants, they were there in the previous round. That is on instructions I'm saying. And those orders are also before the Lordship's court. In both the occasions, the court said, please furnish them the correct thing. And when we requested for this was not furnished, and instead the termination orders were served. I'm so grateful. And with respect to Gwalpara and 17 appellants in each.
Gwalpara and Dibrugad.
There's 17 appellants in each case.
May it please. Well, I won't trouble your lordship. I'm adopting the same, I'm on the same page as Byron. Only one thing I like to add, that in spite of the direction of the court to furnish them the deficiencies, because when their salaries were withheld, they approached this court. That part was never given by the respondent.
That is recently argued the same thing.
And in fact, my entire argument is that the summary, they were holding a civil post and they were visited with civil consequence. Naturally, the entire procedural substantive requirement of Article 311 has to be given. Whereas a summary procedure, which is an unheard procedure, was called for by the respondent authorities.
Yes.
And we were paid a salary without any demur from the finance department. And in fact, so I won't trouble lordship. So my entire argument is that the entire principles of odi alteram partem was being violated. And I am referring to this latest judgment because it covers the entire law from Tulsiram Patel, because Tulsiram is the classic case. 2023 6 SCC, page 1. I'll just read one paragraph. Paragraph 64. Well, I won't trouble your lordship with much. Odi alteram partem has several facets. Can I read, lordship?
Yeah,
It is at page 23 of your lordship's paragraph 64.
including the service of notice.
To any person against whom a prejudicial order may be passed and providing an opportunity to explain the evidence collected. In Tulsiram Patel, this court explained the wide amplitude of the concept of odi alteram partem. The rule of natural justice, which we are concerned in these appeals and writ petition, namely the odi alteram partem rule in its fullest amplitude, means that a person against whom an order to his prejudice may be passed should be informed of the allegation and charges against him, be given an opportunity of submitting an explanation thereto, have a right to know the evidence, oral and documentary, by which the matter is proposed to be decided against him, and to inspect the documents which are relied upon for the purpose of being used against him, to have the witnesses who are to give evidence against him examined in his presence, and have the right to cross-examine them, and to lead his own evidence, both oral and documentary, in its defense. The process of a fair hearing need not, however, conform to the judicial process in a court of law, because judicial adjudication of causes involve a number of technical rules of procedure and evidence which are unnecessary and not required for the purpose of a fair hearing within the meaning of odi alteram partem rule in a quasi-judicial and administrative. And in fact, after the Binapane's case, the distinction between judicial and quasi-judicial is no more. Okay. In fact, the summary procedure which has been adopted by the respondent is akin to proviso to 311, which is an exception to the rules of natural justice on grounds of security of the state, or where the government has the power, provided it's on objective basis. In our case, we sought for the documents because we wanted to, because we were getting a salary, our new pension schemes were supposed to be opened up. We had a legitimate expectation. It is at that point of time we were called by the director, joint director, to come and report on 3-4 occasions. So I pray that our petitions will be allowed. I'll give my summary written submission. Oblige.
Now this 9 and 11.
Without going into much of it, madam, what has happened is that when the first show cause notices were issued to us, we had to approach this honorable court. There were particular orders in 3 rounds of litigation saying that the precise deficiency has to be pointed out. That deficiency was never pointed out to us. The entire termination orders have come only on the basis of a report of a screening committee. This screening committee report was neither furnished to us at any point of time, neither was it placed before this honorable court. Now that in this writ petition 1931 of 2020, where this appeal is being well considered, there the respondents had filed an affidavit in opposition taking a specific stand that it was the rules of 1971 which had been violated. During argument stage, my lord, a second affidavit in opposition was filed saying that the rules of 1997 were being violated. Two affidavits, two stands.
As per this, in the earlier cases, they prepared a chart for that, these are the reasons for your services have been terminated.
My lord.
Those are the same reasons?
The reasons are the same. We are the same batch of persons.
This is no appointment by the joint director who is not
Yes,
competent.
yes. The same.
SIU approval one out there.
My lord, that is what I was trying to find out. Neither in the show cause notices we were told that these were the deficiencies.
These deficiencies they have not pointed out, and simply these are the reasons on the basis of which the respondents are justified your termination.
That is
These
what I was,
three reasons.
three reasons, but then these three reasons in our particular petition, there was an affidavit in opposition already filed, which referred to 1971.
And then thereafter another affidavit which says 1990.
In another petition, not supplied to all of the petitions.
Another petition.
My lord, there was a batch of petitions. In our petition, they filed an affidavit in opposition saying that this is 1971 rules. It was violated, it was a ministerial rules. That I have given in my writ appeal, if lordship would have, my lord, 400 page, my lord.
Jayant Hazarika.
Jayant Hazarika. In that particular matter, the affidavit in opposition file specifically refers to the 1971 rules.
Yeah.
At this stage of argument, an additional affidavit is filed saying, sorry, it is 1997. It is not even a sorry. It is 1997 rules which are not followed. So therefore, during that decision making process, whether it was the 1971 rules which was in their mind, whether it was 1997 it was in their mind, or whether it was a situation where they sought to terminate us, then justify by saying that, okay, we can depend on this rule to say that, yes, it was not followed. Was it a case of putting the cart before the horse? These justifications have come up in affidavits. Separate affidavits quoting separate set of rules. And other arguments were saying that the committee consisted of only 3 persons, or that the learned single justice himself held that it's an admitted position. We have an advertisement, we have a merit list, we have it was sent for approval. Thereafter,
your case belongs to which district?
Dibrugarh, my lord.
Dibrugarh,
my lord.
Dibrugarh is the same.
Same, my lord, but what was not referred to is only what I'm referring to, the presence of 2 affidavits, bringing on 2 different set of rules, trying to justify our termination. And as of today, we do not know whether the screening committee held 1971 was not followed or 1997 was not.
These proceedings are all of Gwalpara and Dibrugarh, right? Any
There's
other
another district, my lord.
Yeah.
So lordships may perhaps consider the fact that the justification has come after the termination. It all started at a stage when surveillance workers were found to have joined in districts with
that he has already left.
Transfer orders, my lord. That is how it started. Everybody was scrutinized. Where it was only a transfer order initiating an appointment. Those cases are different. Ours is a case where we had a proper selection. The petition is also on record in the in 2 places, they specifically say it is 1997. That lordship would find at page 478 of item number 9.
Yes.
Should I read out the paragraphs of the affidavit, my lord?
Read.
They say at paragraph 5 that with regard to the statements made in paragraph number 3, page 478 it starts. Second compilation.
Page you placed on record every appointment order and every termination order.
The entire petition had to come on record, madam. That was the difficulty. We have not repeated it. Whatever was there in the petition, we have annexed the petition. That is the procedure followed.
400?
78, my lord.
Yes.
This was an affidavit by the Director of Health Services, which was filed on 6/4/2022 at paragraph 5, Lordship will find.
Yes.
Page 480. That with regard to the statements made in paragraph number 3 and 4 of the repetition, the deponent begs to say that the Joint Director of Health Services is not the authority to advertise for appointment of grade 3 and grade 4 posts as per Assam Directorate Ministerial Services Rule 1971.
And these rules, 1997 rules are?
1997 rules are district. Key rules has to 1997 rules. I'll just point out. Those rules are
Assam Public Services, direct recruitment to class 3 and class 4 post rules 1997. I'll please.
And then Lordship would have paragraph 15. 15, my lord, at page 483.
Again, this same.
Same, my lord, 1971 rules is what they refer to.
In your this petition,
this was the
the
affidavit.
stand was that the rules of 1971 has not been
71.
followed, whereas in other petitions, rules of 19, they have referred to rules.
One
of
affidavit was filed in one of the petitions saying that it is the 1997 rules which are not followed, and that was picked up. That was filed during the stage of arguments.
Which petition?
That affidavit was filed. We did not even have a copy of it. Additional.
Here are the 5 these appeals.
That additional affidavit, my lord, I have given. That is in WPC 8220 of 2019 is where they filed that affidavit. And it was
WPC, the appeal number.
That whether that has been appealed from is Nayan Prasad Rabha in Gwalpara. For the Gwalpara district, they had filed that affidavit.
In that petition, they have said 1997, and here
they have said 1971. That was pursuant to an order of the Honorable Court, of course, additional affidavit.
Yes.
Otherwise, one of the other arguments, my lord, I would not repeat. Bless me.
Please, your lordship. In item 11, my lord, these appellants are from the district of Shivsagar.
Shivsagar, yes.
The facts of this case starts from the year 1999, my lord. Page number 268, page 268, volume 1. Your lordships may kindly come to page 268. Your case? 11. Volume 1, page 268. Lord, this order is dated Shivsagar, the 18th June 1999. In view of flood situation, the following persons are allowed to work as grade 4 workers as casual basis against the institution. Their work institution is mentioned. All these people and few of others have been working since the year 1999. Thereafter, few of them were appointed as a casual workers in the year 2000, 2003 and 2004. All were appointed prior to that cutoff date of SIU Constitution, my lord, Staff Inspection Unit. So all were appointed prior to that.
Club these 99 appointees, 2003, 2004.
The chart is prepared by me, giving the precise date of the casual appointment, the regular appointment, and thereafter a regularization order also given there.
Where is that?
The chart I have filed yesterday, my lord. If your lordships kindly allow me to show that.
আমটো কি আছিলে?
Chart it as page number 1160, my lord.
In this writ appeal, only 9 persons were.
No, 84 appellants are there.
84 appellants.
84.
In this
86.
chart, you have mentioned about only few of the appointment letter and regularization order.
Those are of the year 1999. This chart, page 100, 1160. The column number 3, date of casual services. My lord, 18th June 1999, 7th February 1999. Most of them are in the year 1999, 2000 and 2002. The next column is of page number where these appointments of casual workers were made in my volume 1 and 2. The column 4 is the date of regular appointment. 17 February 2005.
What do you mean by regular appointment?
The regular appointment order is given. If your lordships kindly come to the appointment order.
First, you were engaged as a
Casual workers.
Thereafter, regular
Appointment order is given. So, my lord, this appointment order 268 says that you are the appointed as worker on casual basis against the institution, and thereafter kindly come to page 265 of this volume. So the appointment is given on the basis that, my lord, may I read this 265?
Yeah.
Well, this order dated Sivsagar the 7th February 2005. In continuation of this letter number 3715-25 dated 3rd July 2001, the following workers who have been working as casual basis are hereby appointed as grade 4 in the scale of pay rupees 2,450 to 3,670 per month plus and other allowances as admissible under rules for period 3 months against the vacant post. So this is the same order applied to other appellants also, my lord. Therefore, this chart giving the total complete information.
Thereafter,
A regularization order, my lord. Lordship may kindly come to page number 272 of the volume 1, 272. May I read 272?
Yes. Yes.
My lord. Order dated Sivsagar the 5th month, 5th May, 2011. Order. Services of the following grade 4 employees are hereby regularized with effect from inception of their services against the existing vacant post. So the name of that employee, initial order, and government sanction number. This is a sanction number of that post. So all the appellants were holding a sanction post, my lord. Then kindly come to the chart, my lord. The chart, the regularization order is the same. So everybody having that regularization order in serial number 7, my lord, the column number 7, the date of regularization and page of that order annexed before this honorable court, those were in the read petition also, my lord.
सिंगल में बोला गोलपारा और डिब्रूगढ़ में देखना चाहिए। फिर इनको राजस्थान से रेगुलर सेकंड पोस्ट Is there any allegation of fraud having been
Nothing, my lord.
committed by?
No allegation of favoritism, nepotism, nothing, my lord. They were working from the year 1999, 20 till their removal, which took place in the year 2020, 2020. And they were regularly paid by the department, by the government, my lord. Salary, sleep and everything. All the service benefits were given for this last.
Your services have been regularized
Yes, my lord.
against the posts, vacant posts.
Against the vacant sanction post, my lord. So my first submission is that their appointments have been regularized and they work on these posts continuously, my lord. They draw the salary also continuously for 20 years. And they have been terminated on a common order showing that your documents are not found genuine. This is the one main cause given in the removal order passed against all the employees, my lord.
Yes.
My lord, I am relying upon a judgment by Honorable Supreme Court of India in the case of State of Karnataka versus AML Kesari. My lord,
Already relied.
my lord, the same thing, my appointments are irregular appointments, but not illegal appointments to say that. The another judgment on which, my lord, I am relying upon is a CO Narayan Nagar versus State of Uttar Pradesh. Yes.
What's the citation?
2018, volume 13, Supreme Court cases, page number 432. Kindly allow me to read from para number 7, my lord. Para number 7 at page number 435. The exception is carved out to the judgment of Uma Devi in part 3, my lord. Page number, para number 7.
Yes.
When we consider the prevailing scenario, it is painful to note that the decision in Uma Devi 3 has not been properly understood and rather wrongly applied by various state governments. We have called for the data in the instant case to ensure as to how many people were working on contract basis or ad hoc basis or daily wages basis in different state departments. We can take judicial notice that widely aforesaid practice is being continued. Though this court has emphasized that incumbents should be appointed on regular basis as per rules, but new device of making appointment on contract basis has been adopted. Employment is offered on daily wages basis, etc. in exploitative form. This situation was not emphasized by Uma Devi 3. The prime intendment of the decision was that the employment process should be by fair means and not by backdoor entry in the available space.
Just
Which judgment are you referring?
My lord,
Shivnarayan Nagar.
Shivnarayan Nagar, yes, my
You
lord.
have given me another judgment.
Shivnarayan Nagar.
Read again. Para number 7.
My lord, para number 7.
Yes.
When we consider the prevailing scenario, it is painful to note that the decision in Uma Devi 3 has not been properly understood and rather wrongly applied by various state governments. We have called for the data in the instance case to ensure as to how many employees were working on contract basis or an ad hoc basis or daily wage basis in different state departments. We can take judicial notice that widely aforesaid practice is being continued. Though this court has emphasized that incumbents should be appointed on regular basis as per rules, but new device of making appointment on contract basis has been adopted. Employment is offered on daily wages basis, etc. in exploitative forms. This situation was not emphasized by Uma Devi 3. The prime intendment of the decision was that the employment process should be by fair means and not by backdoor entry and in the available pay scale. That spirit of the Uma Devi 3 has been ignored and conveniently overlooked by various state governments authorities. We regretfully make the observation that Uma Devi 3 has not been implemented in its true spirit and has not been followed in its faith and substance. It is being used only as a tool for not regularizing the services of incumbents. They are being continued to service without payment of due salary for which they are entitled for the basis of Article 14(16) read with Article 34(1)(d) of the Constitution of India, and if they have no constitutional protection as emphasized in D.S. Nakara versus Union of India, from cradle to grave, in Hades or life they are serving on
The different, this is regarding not paying, making the regular payment and employing the persons on the ad hoc basis or on fixed salary. That
No,
is
no.
in relation to that. How it is related to your case?
Well, they're only saying that the government's practices they are given there.
Not at all relevant.
Kindly allow me to cite another judgment.
Relevant judgment. Okay.
Relevant judgment, my lord. The
Relevant
exploitation.
Mr. Atul,
My lord.
can you please tell us what are your submissions?
My
1, 2, 3.
My lord, submission is that their appointment were not illegal appointments. These were the.
That he has already argued.
Already my adopting the entire submissions raised
What
by
is
them, my
your-
lord.
your-
Exploitation is
your
there.
argument,
That is
anything new?
that is the only argument.
Then
That in my case, regularization has been done.
Yes,
my lord.
that you
That-
you may highlight this, that in your case, regularization was
Regularization is-
done against the vacant post.
My lord.
That is
That
the
is
additional feature.
That is the additional.
Otherwise, all these things.
All things are covered. I'm grateful. Great.
Is all the arguments. Yes, sir.
Regarding that affidavit issue, Lordship, 2 affidavits were filed.
71 and
Yes,
97.
it was a common hearing, and during the course of hearing, the same copy was furnished to all the councils. In fact, Mr. Learned Counsel Ranak Sinha, it was given to him. He at that point of was representing the same councils. So there is not a case that we are taking different stance and we are hiding certain things from one
No,
request.
but the fact remains that 2 affidavits were filed in 2 different petitions, wherein
And
one
it-
incident was that 97 rules were. not
Absolutely,
followed and
Lordship.
Another is 70.
And therefore, the same affidavit was furnished to all the councils. The subsequent affidavit, the second affidavit. Additional affidavit was submitted to, or because basically the law issue was being highlighted here. There is no factual differences. The issue of which act, which law was violated in there.
So now your stand is 97 rules were not.
1997. So there is no dispute on that. And therefore, the learned single judge also referred to the 1971 as well as the 1997 rules. And it was a common hearing. So I'll place basically what the learned single judge found, that there was no SLEC approval, or in the other way was from 2005 it was SIU. So there is a change of nomenclature. So that is number one. There is no power and authority of the joint director to start the process of recruitment as well as the issuance of the appointment order. Violation of rule 5.3, my submission is violation of the whole rules. I'll be adding further. Then there was a ban period during that time when their appointment was done. Till 2006, from 1999, there was a Assam ban regarding any kind of recruitment. After 1999, the first recruitment as per law, as per the government's approval, was done in the month of January 2006. All the records I'll place from my second affidavit. And also, the selection body, etc., were not done. Neither the advertisement was issued in the right manner. In one advertisement, it is said that only few posts are vacant. The other case, it was 70 posts are vacant, but there was about 100 applicants and 81 were appointed. So that way also there are violations, but I am not on that. My first requirement is, Lordship, that the appointment order must be issued by the competent authority. The law is very well settled. If the appointment order is not issued by the competent authority, all other things, including the principle of natural justice, need not be followed at all. That is the settled position of law from 1973 till 2019. I'll place the one judgment which covers all the law laid down earlier also. Yeah. But before that, I would like to place the relevant law because the facts are almost undisputed now. I do not have to place the facts. I'll just take your lordship at one point of time, the findings of the learned single judge on these points at a later stage. But let me first place what is this 1997 rules. 1997 rule is called Assam Public Services Direct Recruitment to Class 3 and Class 4 posts. Rules 1997. Have a copy of lordship. It is in the Assam Service Manual. There's a blatant violation of these rules. The joint director has no business without any approval from the government to initiate the recruitment process. Not to speak about issuance of the appointment order.
Page number?
If it is the same book, I'm not sure if it is the same book. It is by B. Ahmed, Dr. B. Ahmed.
Yes, yes.
Yes, page 131. More or less, it will be nearer that only because Lordship is holding a newer version.
Yes.
So Assam Public Service Direct Recruitment to Class 3 and Class 4 post rules 1997. And Lordship will kindly come to section 2A. Definition. Section 2A says appointing authority means authority to whom power of, I'm sorry.
Just
So appointing authority have got 2A.
yes.
Appointing authority means authority to whom the power of appointment is delegated. So my submission would be from records I'll place that there is no delegation of power to the joint director. The government delegated this power to the Director of Health Services and Director of Health Services Family Welfare in 2002. Those records are part of the second affidavit. So appointing authority means the authority to whom the power of appointment is delegated. Then Lordship will kindly come to applications, Rule 3. These rules shall apply only to those Class 3, both technical and non-technical, and Class 4 posts where there are no service rules, executive orders regulating the recruitment and conditions of service, and not within the purview of the commission. These rules shall not apply to the following cases. So in our case, at that relevant point of time, there was no rules covering the recruitment and conditions and services of the ministerial staff of grade 3 and grade 4 post in health department. So this rule is directly applicable here. Now, rule 4, direct recruitment. Direct recruitment shall be made on the basis of recommendation made by the selection committee in accordance with the procedure hereinafter provided in this rule. Before the end of each year, the appointing authority shall make an assessment regarding the existing vacancies and likely number of vacancies to be filled up by direct recruitment during the next 12 months and shall intimate the same to the selection committee together with the details about reservation for the reserved categories, etc. The appointing authority shall advertise the vacancies, giving details, etc. At the district level, the advertisement at the district level is below, deputy commissioner of the district in which the office of the appointing authority is situated, etc. This is not very relevant. Now coming to 5. Constitution of the selection committee. 1. There shall be constituted different selection committees for selecting the candidates in class 3 and class 4 posts in different offices of the state for which no service rule or executive orders are in existence and are not within the purview of the commission as stated herein below. The selection committee for the post of district level offices, divisional offices, like those under PWD, forest, etc., and below district level, the composition of the selection committee shall be as under, there are 5 officials. The appointing of the senior most of the department, the departmental officer, officer of the rank of ESC up to SDO, and officer of the department other than the department to which the necessary vacancy arises to be named by the deputy commissioner. And 5, an officer of a department other than the department under which the vacancy arises and the department from which the deputy commissioner has nominated an officer as member of the committee to be named by the appointing authority. So in one of the case in Gwalpara, according to their own submission, 3 persons were there. And the learned single judge also taken note of this violation. Then next lordship will kindly come to rule 5's next page, sub rule 3. After that, during the advertisement, this instruction has to be issued by the department. Now, what is that department? It is the government. 5.3 says, the administrative department shall issue instructions on the following. 5.3.
Yes, the administration.
Yes. So here the role of the government comes now. So department have to issue instructions on the following. What are the instructions? The minimum essential qualifications for direct recruitment, the number of essential experience, there should be a written test, and if so, name of the papers and the maximum marks for each paper, whether there will be typing test, etc., whether there will be an interview, and if so, maximum marks for the interview. So this is where the role of the government comes. The government will instruct under what process the selection will have to take place, the criteria of selection. Then this rule governs including the appointing authority as well as the selection committee. This rule also governs and prescribes that what will be the number of vacancies after annual calculation, assessment. Nothing of this sort has been done at all. The joint director on his own volition issued the advertisement in one paper called Spondan. We have never heard that paper. In Dibrugarh, the advertisement was issued in the district office as well as in one newspaper called Spondan. It's an unheard newspaper in Assam. And the other newspaper, it is Khobor, whether it was actually published or not, we do not know. They have, I am not on those, but how the things have developed. And in one of the observations, 70 posts were advertised, 103 applicants. It is an impossible situation in nowadays situation when the qualification is prescribed as under class 8. In 2005 also, the situation was not much different. there would have been at least 20,000 to maybe 50,000 applicants if the advertisement was issued in the proper manner. For 70 posts, 100 applicants. It is unheard of in Assam. But in any case, I am not on those. Now, what the learned single judge have directed. Good. So there. So Lordship will kindly come to page 457. This is volume 3. Because one round of argument is, one limb of argument is that there
Voluntary of which writ appeal?
Lordship, this is 428. Items, item 8.
Narayan Prasad Raba,
Yes, Lordship.
4, volume 4,
Volume 3, page 457.
No, it's not matching.
This is not.
Volume 3.
Volume 3 starts from 601.
301, it starts from 301. It starts from 301. The volume starts from 301. Lordship, volume 2. Volume 2.
Volume 2. Yeah, 301. Yeah, 457.
457.
Yeah.
The learned single judge's order dated 18/5/2018. May I read this, Lordship? This case was taken up on 16/5/2018.
Yes.
This case was taken so and so and adjourned to enable the departmental council to receive urgent instruction, which are as following. So the instruction has come, paragraph 2 now. The basic apprehension projected by the grade 4 employees in the health department is that they were suspected to be non-genuine employees and were subjected to repeated screening, and now they are expected to appear once again before the authorities as per the latest notice published on 27/4/2018. The petitioner contend that in none of the notices issued by the Director of Health Services, the precise deficiency in the petitioner's appointment status were indicated, and the employees are entirely in the dark on why they are being suspected and subjected to repeated screening. On the other hand, so and so submits that the last notice, which was issued on 27/4/2018, was intended to enable those employees who did not appear before the screening committee earlier and failed to produce the documents relating to their appointment. It is also another opportunity for everyone to furnish additional documents if needed. The respondent's lawyer submits that eventually when the screening process gets completed, individual decision for each employee will be taken with due intimation to the affected employees, and only thereafter, if anyone is found to be non-genuine category, the appropriate order will be issued. With the above projection, the learned Additional Advocate General urge upon the petitioners to appear before the Director of Health Service during the ongoing screening exercise. The above stand taken by the state authorities should considerably assuage the apprehension of the petitioners. The petitioners are therefore directed to avail the opportunity to prove their bona fide of their appointment so that the authorities can reach an appropriate conclusion on their service status. As the proposed screening is scheduled to end on 28th May 2018, so and so assures that it will be extended until 22nd of May 2018 to enable everyone to participate in the screening process. If anyone is found to be non-genuine amongst the serving persons, the authorities must, however, indicate the precise deficiency and afford opportunity to the affected employees before any adverse action is taken. It is ordered accordingly. So that learned single judge very categorically directed us to indicate the deficiency. Now, that deficiency has been indicated in the show cause notice. Okay. Lordship will kindly take now page 647 of volume 3. Six 47.
Yes.
With reference to the letter quoted above of the Director of Health Services, Assam, the following deficiencies have been found against you as suggested by the screening committee during screening. Appointed by the Joint Director of Health Services, Gwalpara, by letter dated 2010-2005, no DHS approval, that is Director of Health Services, and no SIU approval. It should have been SLSC, Lordship. There is a change of nomenclature in 2005. Earlier, it was SLSC. Hence, you are hereby so opposed to why your appointment should not be treated as fake, having above deficiencies. You are therefore directed to prove your genuineness of your appointed within 7 days from the date of issue of this letter, and to submit the same to the office of the undersigned to communicate the matter to the Director of Health Services, Assam, as per letter quoted above. So we have indicated 3 deficiencies, and these deficiencies were found by the screening committee. The screening committee's report is also part of the records now. Yes. Page 626. Same volume.
Six 26.
626. It is maybe horizontal wise. The chart is there. So whatever the screening committee has given, it was reflected in the show cause notice.
You have not clarified in your show cause notice that the joint director was not competent.
Yes, I'll come to that, Lordship, straightway, because
You simply said they appointed by, this is a fact you have mentioned.
we have, because he is not the competent authority.
You have not mentioned in this show cause note.
In the show cause notice. Yes, now if we have to read the first paragraph along with serial number 1. First paragraph said, with reference to the letter quoted above, the Director of Health Services, the following deficiencies. So deficiency is that appointed by the Joint Director, number 1. That is the deficiency number 1. But the language, but still, whether it is Joint Director or Director, Lordship, the facts are crystal clear now. Whether now we have to see whether the Joint Director is the competent person to start the recruitment process without government's approval, as well as issuing the appointment order. While removing, it was the Joint Director, because the Joint Director was given and delegated power by the Director in 2019 to issue the removal orders. So issuance of removal order by the same authority, which my learned friend was arguing on the basis of the General Clauses Act, that is not actually tenable now. That argument will not hold.
Any action initiated against?
Yes, Lordship, not only him. Lot of people are already jailed. The Director of Health Service was also complicit in the other case regarding the surveillance worker. Actually, we wanted to find out the illegal appointees in surveillance worker. Then these were the offshoots. We found 412 numbers of illegal appointees in grade 4 and about 1,000 in surveillance worker. In Assam, there are 2 major departments where there are illegalities. One is education department. It is a mammoth thing. The Honorable Supreme Court from 2001 onwards, highlighting all the anomalies, excess appointment. If the advertisement is for 4,400, were given appointment without qualification. Most of them are under metric. They are teaching, Lordship. So these things are that happened from 1991 to 2001. And the cleaning process, we are at the last stage now regarding the education department. And while education department was being cleansed, we have found that in health department also this was going on. So in the surveillance workers thing, it was the modus operandi was totally different. They went and joined in Jorhat, and just for lordship's information, they went and joined in Dibrugarh and Jorhat, which has transfer certificate from Kokrajhar or some other districts of Lower Assam. From the date of their joining in the place on transfer, they were getting all salaries. There was absolutely no appointment at all. That way we found this whole malaise. And when we are trying to find out this, then we found that joint director is running this shop all across the state. In almost all districts, the joint directors were called. And in some cases, the director of health services also. That is why, and treasury officers also, because the salary should not have been given. Why is this SLSC and SIU there? Once a person is appointed lordship, within 6 months, he is not getting the salary monthly. After that, during that time, it is the job of the SLSC or the SIU, staff inspection unit, to verify whether he has been regularly appointed against a sanctioned vacant post, number one, and whether there is a post in existence or not. That's why in education department, when 40 posts were advertised, 400 were appointed, they were getting salary. Finally, this honorable court had to find at one point of time that on rotation basis, salary has to be given. Because the number of posts, the salary, the budget allocations are fixed. Here also, only because the treasury officers were involved, that is why this was possible that they got salary for such a long time. But long elapse of time will not dilute the original illegalities or nullity of the appointment order. So the screening committee found these are the three basic things, because ultimately the joint director is not going to pay the salary. It is from the government's coffer, it has to come. The budget, the assembly. So the director approval is not there and SIU approval is not there. So SIU, it should have been SLEC, lordship. I fully admit there is a change of nomenclature in 2005. So in our so-called notice, we have indicated
SIU, there was a SLSC.
Earlier it was SLSC. And SLSC imposed the ban in 1999. When there is acute financial crisis in the state, there was a moratorium on fresh appointment. 1999.
State level employment or empowered committee?
Empowered committee.
Empowered.
SLEC, State Level Empowered Committee. Then in 2005, this SIU Staff Inspection Unit came and a new act we brought in 2005, Assam Fiscal Management and Budget, AFRBM, Assam Fiscal Responsibility and Budget Management Act. Therefore, Education Department and for PWD, we have brought this act. Why it is for Education Department? Because of excess appointment. Until and unless there is a clearance from the SLEC or the SIU, no authorities can issue advertisement. There should be fixed number of posts so that there is no case of non-payment of salary. And in PWD, a lot of engineers issued work orders without there having a budget allocation for a particular work. Therefore, as a whole, there was amassment of huge number of contractors' bills cases in this honorable court. So we brought that act and that act is still in force. So when they say that they were not given this screening committee's report is very clear. 3 deficiencies and 3 deficiencies were highlighted in the so-called notice. Now we have to see this the edition second affidavit, page 1102 of volume 4. Page lordship, it is page 1102. paragraph 3 onwards, Lord, because this will give the actual factual position which was prevailing at that relevant point of time from 1999 to 2006.
Yes.
May I read it, Lord? Paragraph 3. By way of an additional affidavit, the deponent begs to submit that the government constituted the state level empowerment.
1002.
1002 it starts, paragraph 3 at 1004.
10, yes.
Additional affidavit by respondent number.
110.
110.
110. Yes.
May I read it, Lord? Paragraph 3. By way of an additional affidavit, the deponent begs to submit that the government constituted the state level empowered committee, SLSC, comprising of the chief secretary to the government of Assam as chairman, the commissioner and secretary finance department as member, commissioner and secretary planning and development department Assam, and secretary personnel department as member secretary to optimize utilization of the services of the government employees. The aforesaid state level empowered committee was constituted by the office memorandum dated 6/12 to 1999. As per the OM, the commissioner and secretary and head of department of the concerned department should attend the meeting of state level empowered committee as and when called for. The said memorandum further provided that existing vacant posts, including those that might fall vacant in the future, would not be filled up either by direct recruitment or by promotion without the approval of the state level empowered committee. The aforementioned office memorandum dated 1999 was circulated to all the principal secretaries, commissioners, and secretaries to the government of Assam of all departments, by later dated 7 December 1999, issued by the commissioner and secretary to the government of Assam, finance department, and to all the deputy commissioners and sub-divisional officers by WT message dated 22/12/1999. The selection and appointment of the writ petitioners in the respect of the current writ in the district of Gwalpara as well as writ petitioners so-and-so in the district of Dibrugarh were made during the tenure of the state level empowered committee in February 2005 by the Joint Director of Health Services and the Joint Director of Health Services, Gwalpara and Dibrugarh. So this 1931, I think my friend Learned Counsel Mojumdar appeared, and the other Dibrugarh, my friend, I think Mr. Goswami appeared. These are the two cases. And these are annexer A, B, and C. May I please that annexer A, B, and C at page 1115. December 1999, Office Memorandum, Constitution of the State Level Empowered Committee to optimize utilization of services of the government employees. These are the persons, 4 persons, Lordship. And the committee shall, number 1, examine the requirement of actual number of staff based on workload in each department office and determine the shortage surplus government employees in any department. Examine if the requirement can be met by rationalizing the existing staff, if necessary by redeployment of the existing staff in any department. 3, examine which are the posts which cannot be kept vacant and cannot be manned by redeployment and accordingly recommend to fill up the post. 4, the committee will complete the work serial number 1 by 31/3/2000. The committee shall determine the modalities format in which the required particulars shall be called from various departments. Personnel B department will act as nodal department and provide the ministerial report of the committee. This is very important. The existing vacant posts, including those which may fall vacant in future, will not be filled up either by direct recruitment or by promotion without approval of the state level empowered committee. When they were appointed, this committee was in force. Then next Lordship will find 1118. The same thing has been repeated. It has been now, the first letter was the office memorandum, then it was circulated on 7 December, next day, to all principal secretaries, commissioner and secretaries to the government of Assam, And the second paragraph highlighted bold one, the existing vacant post and also the post which will fall vacant in course of time should not be filled up by either promotion or by direct recruitment without approval of the SLSC. You are requested to issue necessary instructions to all the appointing authorities in your department in the light of the office memo quoted above. So all the commissioner and secretaries, principal secretaries were intimated.
Who was the person at that time appointing authority was the director?
Director, because two, three subsequent documents will clarify that. Then page 1121 and one question, Lord, say what action we have taken against those erring officials. Most of them are facing trials now. Most of them were arrested, got bail, and the trial is going on. Even the director at that point of time. If Lordship go, when I go to the lower court, sometimes I always meet him. He appears in the trial now.
Earlier you were advocate.
I was representing health department. So
health department. So, earlier those were your
yeah,
clients and therefore you are meeting them.
Those were known to me, Lordship. They messed up everything, Lordship. That is why it is actually it is a tragic story. Now, then 1122 annexer D. The undersecretary wrote to the DHS and DHS FW 11th April 2002. This is very important. That will clarify Lordship's query. The undersecretary to the government of Assam, Health and Family Welfare at A department issued to the DHS Assam and the DHS Family Welfare. There are two directors at that point of time. So the joint director of health services of the districts comes under DHS Assam, number 1. I am directed to request you not to issue any kind of appointment order until further orders, even in cases against which permission of the state level empowered committee and approval of Honorable Minister Health and Family Welfare has been obtained until further communication. Please issue instructions to all concerned accordingly. So there is a specific direction from the health department to the DHS Assam on 11th April 2002 not to issue. So that is why the Director of Health Services Assam and Director of Health Services Family Welfare Assam, these are the two appointing authorities under 2A of the rules of 1997.
That
delegation. There was delegation to the director. Joint director have never got that.
This letter speaks that they issued a direction not to give appointment. But where is the delegation to the director?
If we go
director, this health services being act as a appointing authority.
Now here, whatever question is coming up from Lordship, it shows that whether the director is the appointing authority or not. So the government, the health department says the director, you don't issue the appointment letters.
Mr. Saikia,
Lordship.
this letter has a very crucial role in this matter.
Absolutely.
Therefore, some clarification is required.
I'll bring Lordship.
Number one, show us something which is clinching material to show that except for the director, nobody else could have issued any appointment order.
Lordship.
Number one.
Lordship.
Number two, what is the meaning of please issue instruction to all concerned accordingly? Does it mean that the director was asked to restrain others from issuing appointment orders, convey it to them? Because if they are the only appointing authorities,
Lordship, the last
what
line.
was the need to ask others not to issue appointment order? So these are two clarificatory.
Yes, Lordship. Then I have to file an short affidavit to this point.
Show us, this is the order whereby these are the appointing.
Because now it is in the writ appellate stage. I cannot add any document. But if what was the prior to this, there must be some documents. So these documents also we file in the additional affidavit. When the Lordship, this whole system was rotten at that time, it is very difficult to get all the papers at the right point of time.
No.
Now, we'll get it.
Mr.
We'll find it
Saikia,
out.
please understand.
But one thing is very clear. Where is the delegation of power to the joint directors to issue? That is not there.
Correct. What we are asking you is first we have to be convinced which we may be, that it was only the director who was authorized to issue appointment.
Absolutely, Lordship.
Then the question would be, was that power delegated to the joint director?
Yes.
But if there is nothing to show that director was the only authority, then the argument of delegation may not have so much of force.
I fully agree.
That's why we are pointing it out.
That is why the screening committee, the first ground they have taken three grounds. The main ground they have taken, or in the so-called notice, that the appointment orders were issued by the joint director. We have to understand that the joint director is not the competent authority to issue the appointment orders, and that is the reason why the removal orders were subsequently issued.
Correct, but what is the basis for that conclusion?
Yes, Lordship, I have to find out, because in the education department, the rule itself says it is the director of the directorate of the education department.
Correct.
Here it is not there.
Is there any such rule here?
No, that is why this 97 rule is applicable. In education, we have the different rules. That is why under section rule 4, education department is exempted here. Rule 3, application of this rule of 1997. Education department is exempted. Rule 3 says, this rule shall apply only to those class 3, both technical and non-technical, and class 4 posts where there are no service rules, executive orders regulating the recruitment and conditions of service, and are not within the purview of the commission. These rules shall not apply to the following cases: post of the so-and-so. 3, the post of teachers under education department, post of police under home department, post of establishment of Raj Bhavan, etc. So there is a separate service rule.
So, Mr. Sekya, just for more clarity, let us accept that these rules, mutatis mutandi, will be applicable in case of all recruitments made in grade 4, grade 3 in the health department.
Lordship.
Now, the rules mention about appointing authority, but it does not say who will be the appointing authority.
Who has got the delegation?
Power delegation.
Who has a delegation?
Correct.
The joint director was never delegated because
No,
government
that's
knows
right.
that.
But was the director ever delegated?
Definitely prior to 2002, there must be some notification.
It's important
Some
to
communication must be there.
It's important to take note of this query.
Yes.
Because we are now faced with arguments coming from the appellant side who are saying that we have been thrown out of the system in an unceremonious, illegal manner. So to test this argument, we have to find out what is the reality. Then in Rule 4, direct recruitment
Lordship.
only says it should be by a selection committee recommendation.
Lordship.
Here also there is no mention about who is the authority to issue appointment order. Now, since the primary ground taken in the show cause as projected is that the joint director has issued the order of appointment, meaning thereby that he was not authorized. That has to be at least borne out from the provisions of the rules or some circular. Otherwise, this is not an allegation which the petitioners need to answer. That's the point we're making.
Lord.
To get the clothing of an allegation, there has to be notified legal provisions which will show that he was not the authority. If it is an internal departmental communication, a legal issue, a purely legal issue, then the matter is different. But if it is a provision of the rule, then merely saying that joint director has issued the appointment order becomes an allegation because everybody is supposed to be aware of the published rules. But supposing there is no published rules as to who is the appointing authority, then will it be an allegation which the appellants can at all answer? This is one facet which may crop up. Therefore, we are just putting it to a notice. The other two things are fine. Their arguments would be on that these are not illegal but irregular. That you may answer, you will have answers. But this is very important. The first point is very important.
Now,
unless there is a notified rules, this is not an allegation.
Page 1010 for a moment, Lordship.
1010.
Yes, the same. Of the same. 10. This is volume 4. Yes, 1010.
Yes.
So the director at the time of issuance of the removal order delegated the power to the joint director.
Yes, he authorized it.
He authorized.
That you have already mentioned.
No, I have not shown it, Lordship. I'm showing.
No, you have
I've
already
referred.
mentioned that the director has authorized. the
Authorized.
joint
Here,
director
these letters, so there must be some documents prior to 2002, which entrusted the director to issue appointment orders. So
Maybe.
for that, I have to do some fact-finding exercise. I have to find that record. Because if that is so crucial, Lordship, definitely it has to be brought to the notice of this honorable court. And my whole trust on 3 Supreme Court judgments very clearly says, if the appointment order is not issued by the competent authority, then the honorable court may not go to other aspects at all.
Correct.
Even natural justice need not be complied with in that case.
Yes, but it has to be established to unimpeaching.
Exactly,
unimpeachable
Lordship.
material.
50% I think I have satisfied, but the rest 50% I have to.
No, rest 50% in relation to these 3 writ appeals you have argued. But in relation to the 4th.
The 4th case is the worst case for me. I know that
That is
regularized.
regularization,
Only thing
casual
that is the
employee,
actual case
there
where
was
I am little bit
no-
apprehensive now, because that was not argued earlier. So anyway, I'll argue on that, because Uma Devi's case 10 years on 10th April 2006, those who have completed 10 years. And ML Kesari in 2008.
Sir, it is not that their services were regularized while taking into consideration Uma Devi's case.
Absolutely. In fact, we ourselves in Assam, in 2005, we have regularized 28,000 muster rolls and 7,000 workers employees in 2005. And 2006, we had started the exercise, those left out. 13,000 we have already processed. At that point of time, Uma Devi came into force. So rest 13,000 till date, they are languishing. We have completed 35,000 in 2005.
No, that's right. But their case is that they were initially appointed in the year 1999, 2000, 2002, 3, 4 as casual employees. Thereafter,
they were regularized.
Their appointment orders were issued.
Then
their services were regularized.
In fact, their case would have been in a totally different way, because in 1993, there was an OM. That OM was set aside by this honorable court in the full bench judgment in Ojit Kolita's case in 2006. 1993, those who were working prior to 28th of April 1994 or 93, I don't remember that, they were Jitendra Kolita's case. My Lord Justice Gogoi and 2 other judges delivered their judgment in 2006, just before Uma Devi's came in 2006.
1493.
Lordship, remember, Lordship has also done those cases, I'm sure. So at that point, the policy was different. So this 99, 2000, they are not governed by 1993's OM. So their case will be on a totally different footing. If I have to argue that case, maybe they were clubbed together, that's why they are facing the consequences. But their cases, in my humble submission, are on totally different platform. The first 3 cases are different on same page, but the 4th case, Lordship, it cannot be equated with these cases. But I will argue separately for that. But so far, if Lordship wants, then I have to file a short affidavit and I have to find out what was the delegation of power to the director. Because that is a clinching thing. If we do not.
How much time?
1 week, maybe immediately.
These persons were in service during the pendency of the petitions?
No, we came to the High Court challenging a termination.
Huh?
We were terminated prior to filing of the case. We were not in service.
They are not in service for last 4 or 5 years.
At that time, no stay was granted.
No stay
But
was.
now there is an interim order saying
That no vacancies shall be
filled up.
That Lordship will take care, Lordship. Absolutely no issues. I think hardly, or if we add all, maybe less than 170. So that will, every year we have much more vacancies.
In fact, Mr. Saika can be a little more magnanimous. We may not be required to argue it any further. If he says, okay, 170 will accommodate.
No, I cannot do it. This will be injustice to the other persons and this will give handle to the illegal persons.
In the morning, there was a case, they are not ready to accommodate 6 persons. What to say about 120?
No, Lordship, we have done 35,000. We have done 35,000. On the lighter side. But the thing is that the problem is not with them. The problem is those joint directors who open the shop. That is the problem. can anybody imagine that for 70 posts, 100 applications only came?
You just give one this, it is in respect of which district?
Which one, Lord?
This 70 posts and 100.
Yes, it is there in the judgment somewhere. It is, I read it.
It is in respect of which district?
Either Gwalpara or
Gwalpara.
Gwalpara or yeah, Gwalpara, and there is no mention.
You give us a
Lordship, I'll give that.
also detail of that. That in this response to the advertisement, how many persons have applied?
Applied.
The district?
Lordship.
Mr. Gogoi, please make a chart. Who was the director, who was the joint director, and what?
Director, I can say the name right now, but it will not be proper. But at that point of time, the director is facing criminal trials now.
For this reason or for any other reason?
The surveillance order.
No, but not for this.
All are connected. All are connected. Surveillance worker, it is horrible, Lordship.
No, that is correct, but is there any criminal proceeding against?
Here the learned single judge directed for specific.
These
There's a direction of this. I'll find out, Lordship. Otherwise, those.
find out also.
Yes.
Because they may be involved in criminal cases for other matters. But in these cases, is there any?
Because the same persons were more or less involved. Whether this case or that case, I'll find it out.
23rd of July. 24th.
Another case.
23rd or 24th?
24 Lordship was kept item 1, so can be kept on the same day.
Item 1. Item 1 is affidavit. Yeah.
24th?
No,
24th.
Vote 24th. 23rd of July. And parted as part.
Highly
Yes,
obliged.
no, 23rd of July.
They may file the affidavit a few days before, if required, we may have
Yes,
to
yes.
respond.
In advance.
Yes,
may
yes.
please.
If we can, before vacation, we'll try, Lordship.
Fine.
Because if it is delayed, then we sometimes tend to ignore.
Fine.
If it is done immediately, Lordship, we'll definitely try to get it done before 28.
Notes.
Highly obliged.
Lordship is keeping it on 23rd, Lordship.
23rd of July.
Well, great.
Item 12 and 13.
All the states have filed their affidavits, Your Lordship. Arunachal, Nagaland, Mizoram has filed their affidavits, Lordship.
Everybody has filed their. Everybody has filed their affidavit.
Lordship, everybody has filed.
So now what do you want?
What to make, fix it after vacation for Lordship.
You appeared as if you are ready with all the arguments. Let's start to summarize.
Item 14.
Lordship, in this case, Lordship will file an affidavit, Lordship, against the affidavit that the state government has filed, Your Lordship. We'll like to file an affidavit reply.
And then they have filed the.
Lordship, on 3rd of April, Your Lordship.
March. 3rd of April, 2 months have passed.
Lordship? Yes,
2
Lord, 2
months
months has passed, Your Lordship.
Well, in between this summer vacation.
Lordship, there is an interim order that may be continued.
Interim order.
Whenever it is
Continue till. After summer vacation, you go to the registry and take the date of your choice.
So.